Pick Monday.
Similar pyramid.
Motion.
Lordship, I'm praying for listing of an interlocutory application, Lordship. Main case is listed tomorrow, Lordship.
I for?
I have for impediment, Lordship.
Okay. Problem.
May I mention item number 12?
Hmm.
Petitioner challenged the delimitation of the assembly consequences. So perhaps they may not be interested in pursuing the petition. I need an accommodation for a week, Your Lordship, then I'll get my instruction. Item
Not a
number-
week. We'll have it on the Monday.
Very good.
Okay. On a request made by Sri K.P. Pathak, learned counsel for the petitioner, matter is adjourned to be listed on Monday date, to enable him to obtain the instructions. Full stop. Sri GA. Any government counsel? Who's there? Otherwise, Sri Endas, learned state counsel, and Sri A.I. Ali, learned standing counsel, ECI, are present. CGC also we require CGC. Okay, again. Okay, Monday.
My lord, may I pray for a listing of a motion tomorrow? Oblige me.
Yes, please. I think the item number 15 of today's fixed ballot.
Hmm.
Please say, file affidavit.
Can they consent
Yes, sir. Take it.
on a request made by Ms. Egan, learned CGC? Matter is adjourned by 2 weeks to enable, by 3 weeks to enable filing of affidavit in opposition. Full stop. List on. We give a date, madam. We have 5th, 1, 2, 3. We'll have it on 30th of March. 33. Yes,
Please, Your
Mr.
Lordship, I may be allowed to move a unlisted matter today, Lordship.
Today?
Motion, Lordship.
Why?
Because, Lordship, my caste certificate in tuition that may be terminated today itself at any time. Process is going on, Lordship.
That may be terminated. Can we preempt termination?
Because, Lordship, one notice was issued to me. I pray for time. Time was granted on 2nd March and asked me to submit on that day itself. Because it was virtually, they have rejected my prayer, Lordship.
We cannot,
And yesterday and day after yesterday, before
we
yesterday,
can allow it to move it, but will not grant any interim order.
Lordship, let me try my luck, Lordship.
Move it tomorrow at 10:30. Tomorrow.
Lordship.
Yes. Have you filed or not?
Hi, Lordship.
Okay.
May I please, Lordship? I'd like to mention item number 14.
40.
14.
14. Yes. Yes.
So due to my severe unconscious father-in-law died, so kindly adjourn.
Item 14. You're for whom?
So TK Mayor, respondent number 5 and 6.
Okay, okay. Have you informed the other side? On a request made on behalf of Sri T.K. Bhuya, learned counsel for the respondent numbers 5 and 6, who is said to be on bereavement, matter is adjourned to be listed after 4 weeks. List on, we give a date. On 1st of April. 1st April.
Please, Lordship, I'm paying for listing of 2 motion matters tomorrow, Lordship. Much obliged.
Yes.
Similar period of the eviction matter motion tomorrow.
Lordship, I beg to mention a matter with your Lordship's permission.
Yes.
Lord, it's item 11.
Hmm.
Lord, here actually there's a writ appeal pending where there's some interim order passed which has a bearing on this matter. Lord, I
Item
would
number
request-
11.
Item 11, my lord.
You are
Appeal-
not there, Mr. Fukan. Are you there on record?
My lord, Rinku Hazarika, R. Hazarika is
Yes,
there.
yes, he is there. Yes.
Yes, my lord. Yes.
What is your prayer?
My lord, my prayer is if it could be deferred, my lord, because the writ appeal, my lord, we are seeking vacation
Revenue?
of
There's a writ appeal on the same subject.
the writ appeal, my lord, because the question here pertains to mutation, my lord, of land where
Okay,
some
what is
rights
the
have been.
what is the writ appeal number?
My lord, the writ appeal number, my lord, I'll just give the writ appeal number. I'll
Yes,
just
yes.
from the writ appeal number, my lord.
You are A. Fukan.
A. Fukan, my lord.
Sri A. Fukan, learned counsel, appearing online for the petitioner, has informed that there is a writ appeal pending which is connected, and accordingly he has prayed for an adjournment. Also heard Sri Andas, learned state counsel, and Miss G. Hazarika, learned standing counsel revenue, who have endorsed the said statement, said submission. Para? In view of the above, matter is adjourned to be listed after 4 weeks.
My lord, obliged.
Or we give a date of 4, okay, 4 weeks. Don't give it. Okay.
I'll mention, my lord, if the matter,
Liberty is granted to the parties to make a mention if in the meantime the connected writ appeal is disposed of.
deeply obliged, my lord.
If in the meantime orders are passed in the connected writ appeal.
Deeply obliged, my lord.
You try to give the number.
I'll just send across the number right away, my lord.
AC to deliver.
I have received the instruction.
Yes.
Can be taken after some time, right?
Okay.
Intersite, I don't know.
Or
Instruction to
my lord,
completion.
Monday, my lord.
Monday.
I have received the instruction.
So I will do it.
Monday.
If he wants on Monday, we can have it on Monday. Otherwise today.
Monday?
Monday. Okay. On a joint request. No, no. On Sri Das, the London State, Sri and Das, the London State Council has submitted that instructions have been received. Full stop. On a joint request, consideration of this matter is deferred till Monday, Monday,
9, my lord.
9/3/2026.
My lord, in this case, my lord, I am on behalf of AR Talukdar, my lord. He has instructed me over telephone that matter may be adjourned today and may be taken.
18 matter.
On Tuesday, he is out of station, my lord. Tuesday, my lord.
18 matter. How do we adjourn? Yes. What is this?
2 and 3, my lord, some lands were allotted in the name of two parties. We are in possession of our own portion of land, but they have filed the case earlier without making us file.
2 and 3.
No, you are for 3 and 4, Mr. Mahmood.
Yes, yes, my
You are not in this matter. You're for 3 and 4.
a cooperative matter, my lord.
Mr. Aludar, what is this? 18 matter.
My lord, I have filed the affidavit pursuant to the, my lord, honorable court's direction. So my action is on record, my lord.
Why are you seeking time? Mr. You are there.
No, my lord. It will be taken on Monday or Tuesday, my lord.
Monday. Monday. We are not adjourning. A prayer for adjournment has been made on behalf of Sri A.R. Talukdar, who is stated to be out of station. A.R. Talukdar, Land Council of Petitioners. Who is stated to be out of station? First of also heard Sri S.K. Talukdar, Learned Standing Council, Cooperation Department, and Sri private response number 7. Who is for 7?
Yes, I mean.
Okay, Pathamari we also heard Sri Endas, Learned State Council, semicolon Sri S.K. Talukdar, Learned Standing Council, Cooperation Department, and Sri, your name?
That's right.
S. Roy, Learned Council for response number 7. Para, considering that this matter is of the year 2018, while the prayer for adjournment is declined, a short accommodation is granted directing listing of this matter on Monday, 9th. Obliged.
Only one thing, at the time of filing the affidavit, my lord, nobody received the copy. So, my lord, I become DD. I can speak.
May it please your lordship. My lord, I appear for the petitioners in item number 3, while my friend, he appears for the petitioners in item number 4. The issue here is, my lord. Now, my lord, the claim in this petition is, my lord, settlement of the land or allotment in the favor of the petitioners, who are, my lord, 59 in number. They are, my lord, river eroded people, my lord. Due to erosion, they had to leave their land, my lord. They became landless. And in the year 1966-67, my lord, they came down and, my lord, settled in a grazing reserve called Bhugubari village. And there have been, my lord, steps taken for allotment of land in their favor. However, that has not come up, my lord. I'd like to take your lordship to only 2 documents in the writ petition and the affidavit in opposition of the respondent number 2.
Page
If your lordship takes up my repetition,
3550.
3550, my lord. Page 22 and 23. This is a communication from the government to the, my lord, the government in the revenue and disaster management, to the deputy commissioner. Allotment of land in favor of 50 number 9s of landless river eroded person. Has your lordship got it?
Yes.
I am directed to enclose here with a copy of the petition dated 8/1/2014, along with his enclosures submitted by Hafizuddin, which will speak for itself, and to request you kindly to take necessary action on the matter as per existing rules and procedure. Then, my lord, the next page, page 23, your lordship will find, my lord, that is a communication dated 26/6/2015, allotment of land in favor of 59 number of landless river eroded person.
Page
Page 23. With reference to the subject cited above, I am to enclose here with a copy of the government letter dated 6/5/15, along with a copy of the petition dated 8/1/14, submitted by Hafizuddin so-and-so, received from the Deputy Secretary to the Government of Assam Revenue Department regarding allotment of land in favor of the people at Ghugubari Village Grazing Reserve under Rupusi Mouza, and request you to take necessary steps as per procedure. Now, my lord, since nothing fructified, therefore, my lord, they approached your lordship, my lord, by filing this petition. And if your lordship kindly comes to the affidavit in opposition of the deputy commissioner, my lord, district commissioner Borkota. There, my lord,
page
page, it starts at page 38. On behalf of the page 37, it starts, my lord.
yes.
If your lordship comes to page 39, paragraph 4, that with regard to his statements, may I read it, my lord?
Yes. Page 39.
39, paragraph 4. That with regard to the statements made in paragraph 3 of the instant petition, the opponent makes to state that there is no record regarding settlement allotment of land in Ghugubari Vizier land under Rupsi Mouza, Barnagar Revenue Circle, to the river eroded 59 families of village Kamarpara. However, a letter was received from the
Madam, you have a seat. Don't stand like this. Either you have a seat. Yes, madam, make way for her. You are with whom?
However, a letter was received from the then DC Kamrup to ADC Borpata, where it was directed to concern SDC to settle the land. Then paragraph 6, that with regard to statements made in paragraph 5 to instant writ petition, Deepan makes to state that as per report of Circle Officer Bornagar Revenue Circle, the said land cannot be allotted without the reservation as the land is vizier. So, my lord, the stand the Deputy Commissioner is taking is that because it is a vizier land, unless it is the reserved, the allotment cannot be given, my lord. Nowhere they state that, my lord, we do not intend to give the, my lord, and other my lord, facts that they are eroded person. They have been living there from 1966-67. That those are, my lord, not disputed. Therefore, my lord, my prayer would be, my lord, let them take a, my lord, decision as per law. And consider it and give a, my lord, quietus to the issue.
Well, when the law is clear, where is the question of further consideration? Law is very clear, Jaspal.
Yes, ma'am.
Jagpal.
But in the, here, my lord,
At some point, we have to put our foot down. No question of any further consideration. Jagpal is there, Jagpal is there.
my lord, submission before your lordship will be that, my lord, they have not, my lord, denied that we are river eroded person.
That, but not in reserve land.
Maybe, my lord.
Not in reserve land. You apply under the land policy. We have been saying that landless person under the land policy, whichever is presently going on, you apply. If it's applied, You have to be given a due consideration in accordance with law, but not in this reserved area.
Stand, my lord, that has been taken.
That is not the stand, that is not, there is by some officer, maybe by some influence, we will not expand anymore. We have found letters. We have found letters, many letters. This is nothing. This is only for consideration. There are letters to even settle without de-reserving. Luckily, in the affidavit, they have taken a correct stand without de-reserving. The scope of de-reserving is very less, as you know, Mr. Chaudhary. There is no scope as per Jakpal. But we'll definitely make, you apply under the new policy.
My lord, these people staying there from 66, my lord,
That-
they cannot be remediless, my lord.
No, that is why we are saying, you apply under the new policy, you'll be given time. You cannot be evicted just like that in one day. We are giving that much of protection. But that is only balancing the equities. Okay.
I
Yes,
understand.
Mr. Mahmood,
Letter is dated 26/6/15,
which one?
space 23.
Yes. Yes.
I have to that lordship Jakpal.
No, even otherwise, Jakpal you cannot say that it will have prospective effect. Jakpal is law of the land.
My lord, I agree to that, but then, my lord, there has to be some way there where, my lord, they have to be these persons, my lord, just we can, they're citizens of India, my lord.
That will say. Mr. Mahmood, you are for whom?
I
My lord-
am for the petitioner in WPC number 7370.
Similar.
My lord, in fact, our stand in reputation is that we have been staying there for long, but
And-
they are, my lord, some outsiders, all of a sudden they came in and they tried to encroach our land.
Regarding that same PGR land.
Same land, my lord.
Same land.
No, we are not outsider. We have been allotted lands by the government.
Allotted.
Yes,
Let us see your case.
yes.
Can be safe.
No, vice versa.
Vice versa.
You should join hands. You'll be stronger. Your common object, you have a common object to achieve.
Yes. Actually, well,
If you fight, if there is infighting, then you will not achieve the objective.
Actually, well, that is also not our intention. Our intention is that they came earlier.
Who?
Mr. Chaudhary, earlier than us, but
you-
he did not make us parties. That's
He
why
came earlier means to the court or to the land?
in court,
Who came earlier to the land?
the land they came earlier.
When they came
But
earlier.
thereafter, like government should show that we are also landless people. So the government also allotted some.
Yours is 7370.
Yes, 7370. The order from page 29 onwards. Page 29 of WPC number 737023.
23. Page 23.
29. From so and so under Secretary to the Government of Assam to the Subdivisional Officer Borpet. Subject allotment of land at Gauhati, PASG of Borpeta. Reference number so and so, I am directed to say that the Government of Assam is pleased to grant allotment up to 1 bigha.
What is VHJ?
Hello?
What is VHJ? What is the meaning of VHG?
Yes.
I think you have not, this is not village grazing land. I said it should be VGL. The next page is not clear at all.
So, my lord, I am directed to say that the Government of Assam is pleased to grant allotment up to 1 bigha per family to 32 deserving river-related families. For those for house, street purpose and land in sieve for agriculture purpose by these 32 families may be allowed along with 59 original allotted. That is 59 is by ladder phrase. And we are 32.
But Mr. Chaudhary did not have any allotment order. You came later and you managed an allotment order.
Management means, my lord, the government.
Managed only. Original persons have not been given. You came later, you got allotment.
can manage the state authority, my lord.
That you know.
We expressed our grievances and
Okay.
they were satisfied that here these are poor people, landless people, liberated people. So some portion of land were also allotted in our names.
You have 32 numbers.
Yes, I have 32 numbers.
32 how many petitioners are there?
59.
59.
They are 59.
No, in your case.
But 32.
But these are 32 families, they have said.
Yes.
Okay.
Family. Out of the family, 32. So, this was addressed to SDO Civil Borpet at that time.
Is pleased to grant allotment.
Then the Lordship would say to keep their occupation with written understanding to the effect that they could be shareholders, agriculture farming cooperation will form, otherwise will be evicted therefore. So there was some condition was there that we should form a agricultural farm and thereafter we will be entitled. So that is done already by them. Now, Lordship kindly say thereafter letter was issued by the DC Kamrup. At that time, Borpata was within Kamrup district.
Yes.
So with reference to the above, page 32 mile.
But 32 is dated 71. How can it be 71? Allotment is of 75. How can it be thereafter?
71, it is 71.
No, earlier letter you said thereafter. Earlier letter is of April 75. How can it be thereafter?
Communications are left not there, but communication was there. Letter
No, that is not we are hinting at. See, Annexure 1 is dated April 1975.
Yes.
If you say thereafter, it has to be after 75, but thereafter it is in 71. How is it 71?
Long, but thereafter, so many cases were also there. I am coming to that point.
No, we have to explain the date.
That may not.
Why 71? It went back 4 years.
Yes, it may be. It may be so. But 71 may be earlier, 75 may be earlier. At the time of tabulation, it may be a little difference. But orders are genuine and orders that have come from right hand. So, my lord, thereafter, the persons were allotted the lands and they were enjoying the lands
Sanction of governor.
forming agricultural cooperation. And thereafter, my lord, these 59 persons, through their representations,
Copy of the
filed a
letter.
case against their occupation. That may Lordship may kindly see page 32, 33. This Basermia is their man. Now he may be not there, if perhaps he has died in this, as I have been told. So Basermia filed a case before the landed executive magistrate that we have occupied their portion of land. The landed executive court passed order that Lordship may kindly see page 34. Page 34 bottom. Lordship will say, where the Insar Shorbok police station submitted a report on 16/7/85. Page 34 is very important, my lord. On 16/7/85, and from the report it is figured that both the parties, the land was equally shared by the parties. And the first party is occupying 106 bighas of land. After considering all the facts, possession of 106 bighas of land on the west out of 240 bighas is declared in favor of the first party. Sorry, my lord, this first party, Basermia, is our man. I'm sorry for this. The Basermia is our man. So our possession was declared by the landed.
And Falumia?
Falumia is there. Then the landed executive magistrate declared in favor of the first party 106 bighas of land on the west side out of 240 bighas. Total land was 240 bighas. And out of the 106 bighas were allotted in our names for homestead as well as for agricultural farming.
This is a 145 proceeding.
Hello?
This is not a civil court. This is a 145 proceeding.
No, declaration of possession.
No, there cannot be declaration of position under 145.
What?
145 proceeding. See the order at page 33. Copy of the order is the 3 so and so in connection with a proceeding under 145 CRPC.
Yes.
So under 145 there is a limited direction. Okay, you have
Only
got some orders.
declaration, only
Okay.
declaration.
Yes.
So that was done by the learned executive magistrate. Thereafter, the opposite party filed a criminal revision petition. That lordship may kindly say.
Opposite party means Mr. Chaudhary's client.
Yes. They filed a revision petition, page 43.
Where? In this court?
No, before the learned
Sessions?
judge, session judge at Borpeta,
Page?
page 43. 43.
43.
And the learned session judge discussed the matter thoroughly and finally gave its verdict that lordship may kindly see page 50 bottom. Page 50 bottom.
50, 50.
Yes. Lordship would see one of the witnesses examined in the case that block of 106 bighas and block of the remaining portion of 240 bighas of the de-reserved land was well demarcated and the boundary line and the possession was also delivered to the families of the respective blocks. The learned magistrate appears to have considered the entire evidence on record and has come to the conclusion
Petition
that,
dismissed.
yes, their petition was dismissed. So our possession was confirmed. And here one thing lordship would kindly see, the learned session judge observed that the portion 240 bighas of the de-reserved land, it is de-reserved at that time. Now my submission before your lordship would be that when some land has been de-reserved, whether that can be again brought into reserved land, and that too when the person constructed their dwelling houses, that lordship would kindly consider.
Okay, do you have any other document of that the land was de-reserved?
I'm coming. No, that may be perhaps with my learned friend, but it is observed. Perhaps something was there before the learned session judge, and record would say. But whether this record of the year 1987 would be available and in DC office at Borbeta or not, that is a question. But it is true that something was there. Otherwise, how the learned session judge will observe like that? Then lordship would kindly say, page 56. Petitioner Abdul Quddus, with list of names of the persons who have been allotted the land of Bhugubari VRG on 3484 has been prepared. This land's list lordship may kindly see page 57. These are our peoples, the 32 peoples.
What is this 56? Copy of the petition?
Yes, 56 is a copy of the petition and 57 is the list of the persons.
Okay.
And this list was not prepared by us. It was prepared by the circle officer, Bornagar Revenue Circle, with the assistance of Lot Bondos or Kanunga, etc. 60, starts from 60. 60. So these are the list of our men who have been allotted this plot of lands. And this list have been prepared by the circle officer. Then, my lord, we submitted a petition before the deputy commissioner Border, that you have allotted the land in our favor, but you have not issued patras to us. So we filed this petition, that is page 63. And 64 is another communication. Lordship would say this is from ADC Revenue Borpeta to the Circle Officer Bornagar Revenue Circle.
What is the date of 63?
It is by 9/12/2014.
Where do you get 63, 9/12 date?
Yes, page 64, top right side.
No, not this. The petition, P63 petition.
Our petition.
Yes.
No, our petition is not. Our petition is page 56.
No, 63, page 63, Annexure 7. What is the date?
It is dated, my lord. It is not given here. But it is mentioned that Lordship would say is fair for offering patra in the names of allottees of Gugubari BGR already allotted on April 11, 75. That means 11/4/75, there is an order that is quoting. But exact date of this petition is not here. So when it is not there, I cannot look it, my lord. But it is it has the reference of the authorities letter. Then Lordship would say, page 64, 64, Annexure 8. This is the letter dated 9/12/2014. It is written by ADC Revenue Borpeta to the Circle Officer Bornagar Revenue Circle. Here it is said that regarding issue of patra in the name of allottees of Gugubari, de-reserved as river eroded persons. With reference to the above, I am to enclose here with an application in original.
Where is the reserved?
My lord,
De-reserve. Just de-reserve.
it has come from ATC.
Okay. To submit field verification.
But de-reserve, it is not for inquiry. It is already decided by the authority. De-reserve words have been used. It means that at that relevant point of time, when the ADC wrote this letter, at that time the land was de-reserved. Further inquiry was ordered, that is another matter regarding the physical possession or household affairs or agricultural matters, etc. of the 32 people. But de-reserve word is final. Then Lordship will kindly say, the circle officer wrote a letter to the Maujadar. Maujadar, that you submit the list and after proper verification. Now, whether the Maujadar has power or not, that is not the question here, because Maujadar was directed by the circle officer
Where?
to submit the list.
Where is that letter?
I am showing my note. Therefore, Lordship, page 64, last two paragraphs. Therefore, you are requested to inquire into the matter and submit a field verification report.
That we have seen.
As per rule. So this was ADC's letter to circle officer.
Correct.
Circle officer then wrote a letter.
Where?
That letter is not here, but he wrote because it is here mentioned in the Maujadar's letter,
Let us see where is the mention.
as I am submitting.
Where-
Respected Circle Officer, Bornagar Revenue Circle. Please go from here to book. 65.
65. Where is the mention of the letter by the circle officer? This letter is not in reference to any letter.
Please. let me read my note.
Yes, please
With
do.
due respect, I beg to state that on the land of Hugubari village, Vijay at first 240 bigha land was allotted to 59 river eroded families. Thereafter, in 1975, the government, after consideration of the said allotted land, allotted 1 bigha for housing to another 32 river eroded families and further directed that the remaining 208 bigha of land to be used by both the parties on the basis of mutual cooperation for cultivation, and if the party does not agree, they will be evicted. A copy of the government's order is enclosed herewith. So if the government's order is enclosed herewith. Now the government's letter may be with them, but it is referred. So enclosed herewith, herewith excluded. Now it is seen that it from the total 240 bigha land, second part is 32 bigha of housing land is excluded, then 208 bigha of land remains. If the 208 bigha land and the original allotment of 59 families is given, 1 bigha is for housing, then 149 bigha remains. If the 149 bigha of land is equally divided between both the parties, then 59 plus 32 is equal 91 families will each receive a share of 1 bigha, 3 gata, 3 lesser. 59 bigha received by the first party for housing and 1 bigha, 3 gata, 3 lesser received for cultivation, and his family will receive a total 1 plus 1 is equal to 2 bigha, 3 gata, 3 lesser, and similarly second party 32 families will receive for housing 1 bigha plus for cultivation 1 bigha, 3 gata, 3 lesser. Total 2 bigha, 3 gata, 3 lesser will be each family's share.
Yes.
Therefore, I request you that if the total 59 plus 32 families are given, each 2 bigha, 3 gata, 3 lesser for residence and cultivation, the above allotted should not have any objection. As such, I have submitted report for taking necessary action. So, enclosure list of allottees, Assam government's order is enclosed here. So, my lord, the Bojada thoroughly investigated the place of occurrence and submitted.
Place of occurrence.
My lord.
Place of occurrence. You have come to a criminal trial.
The land, my lord. And so, the land was physically visited by the Mojadar, and Mojadar have given a proposal. How the matter can
Yes,
be
we have
sorted
seen.
out.
Then thereafter.
So these things is very much clear. Here land allotments revenues has been also paid. All of these are enclosed here with. And earlier one requisition was filed, but there were some formal defects which was withdrawn and with liberty to file a fresh, and thereafter this fresh case has been filed. Order of the Honorable High Court, page 82 bottom. This court, taking into account the above, permits the withdrawal of the registered writ petition with a liberty.
Page 82.
Page 82. Court's order giving liberty to file a fresh case. So accordingly, this fresh writ petition has been filed. Here, one thing, my lord, my learned friends, clients filed.
Just a minute. Just a minute. For formal, this is not impeding private respondent.
Here, my lord.
No liberty granted.
No, liberty granted.
Okay,
The
liberty.
board into account the above permits the withdrawal of the institute
With liberty.
to be filed by removing formal defects. So, my lord, the other writ petition which my learned friends client filed, that is WBC number 3550/2020. Though there were disputes between the two parties since long, but I don't know whether my learned friend was properly instructed or not, but they have not made us parties in that writ petition. In their writ petition which was filed in 2020, and they know very well there is dispute regarding some possession of area of the land. Even then they did not make us parties. So we had to file the writ petition ourselves, but in our writ petition we have made the parties. And now both the cases are going together. What is to them? Now my submission is this, my lord. Both are poor people. My learned friends, clients, and we are also poor people. And land is already re-reserved. And this Mojada's proposal, page 65, annexure 9 of writ petition number 7370 is a very good proposal. If both the parties agree, then each party will get their own shares and each will be benefited. And if we quarrel with each other, benefit may take by some third party. So, Mojada's proposal, I don't know what my learned friend would say, it may be accepted. And government may accordingly issue patta so that the apple of discord is solved for ever. That is my humble prayer.
Yes.
Apparently, lordship, the land is a vizier land. And from our affidavit of the respondent number 3 in 7070.
In Mr. Mahmood's case.
Yes. Paragraph 6. Page 85.
Eighty
85.
by R3.
3.
Just a minute, please.
Starts from 83. Please. Paragraph 3.
Yes, please.
The first paragraph, we can skip the second paragraph. It is further submitted, as your lordship got it.
Yes.
Submitted that no formal order for issuance of pattas to encroachers has been received from higher authority. Also, there is a bar to provide vizier land as per the Supreme Court's order. Then this third paragraph we can skip, then fourth paragraph.
Yes.
It may further be mentioned here that no formalities and procedure for converting de-reservation of the vizier land and subsequent reservation of other government land as per the Assam Land Revenue Regulation in respect of Bugubari Grazing Reserve has been done. So under the vizier land, lordship, vizier land can be converted under certain circumstances, under specific reasons, lord. Not for allotment of river-included persons. They were allotted at that time of, some persons were allotted that you stay here by forming a agricultural corporation.
So Mr. Mahmood is harping on two documents. One of the documents is a 145 proceeding. We are not too much
No, lord.
giving too much of, because those observations, but there is another observation that the land is de-reserved.
In our affidavit, we have specifically mentioned, Lordship. That is why I have pointed it out at paragraph 6, that it was never been de-reserved.
Because 64, how the ADC has written page 64?
Yes, Lordship, that what I have also said, but from our affidavit, we categorically have stated that there is no such de-reservation. We can clarify that point, Lordship, from the revenue department.
No.
But
Sure.
here, Lordship, though this word is here, others regarding issue of patta to the allottees of Phukubari de-reserved, already allotted. But
So
Lordship, you have
from what,
specifically-
which context this word has come? Earlier communication does not indicate that there was a
Yes, Lord.
de-reservation.
that word is nowhere there. Their right came from the annexure 1, page 29. They are claiming their right. Page 29, that is an order passed by the Secretary to the Government of Assam, Revenue Department. to the
April
sub-
1975.
Yes, Lord.
Okay.
From this Lordship, they are claiming.
But your affidavit is very clear that,
Yes, Lordship, that
okay,
there is no such
formality. Madam, would I like to say anything? After hearing all the case, we'll call for the records. That is your submission. So you say, what is your submission? Okay.
It was never been controversial, Lordship, our affidavit. And they can very well apply for land under the land policy laws. And if they are river eroded, their schemes are also there. They have to prove that they are river eroded. It's a nine, no? So that scheme is no more there. But even then, Lordship, if they are landless people, they come under that land policy.
What was the relief claimed in this petition? What is the prayer? 26 in Mahmood's petition to issue note, to issue patta. To issue patta. And in Mr. Chaudhary's petition, what is your prayer, Mr. Chaudhary?
My prayer, your worship will find at page 16, the writ of mandamus should not be issued directing the to take necessary steps for allotment, settlement in favor of the petitioners on the land. And writ of mandamus.
You are not aggrieved, either of you are not aggrieved by any eviction process.
Presently, till now, not. There is no notice as such.
So we'll not say that say anything about eviction process since they have not initiated
They
anything.
have not initiated.
Our observation, our discussion will be limited to your right for a settlement. That's all.
My lord.
We will not unnecessarily cause prejudice to you unless there is an eviction process.
My submission will be, my lord, the case of Mr. Manu's client makes my case stronger. And my lord, by simply saying that there has not been any de-reservation, can the, my lord, authorities, my lord, nullify communication by the deputy commissioner?
Not by the deputy commissioner.
My lord, it was signed by the ADC, but
ADC.
it is from the
It
office.
is
of
under
the
what
deputy
context that term has come? We are just wondering. In none of the earlier communication, ADC does not have the. He has to get the source that it is de-reserved. Earlier communication, there is no mention about a de-reservation.
But that is a letter of, my lord, 2014.
We've seen that. We've seen that. But since there is no eviction initiation for eviction proceeding, we'll not deal with that aspect. Okay, we'll see the recording. Okay. Bhutan, this is about it. We'll have this reserve, otherwise, no.
Yeah. Right. That's why other thing, Mr. Choudhury said that his case is better. Actually, in my opinion, humble opinion, my case is better. Because we have got two orders from.
Mr. Chaudhary did not say his case is better. He said that he is trying to get some support from your case.
Yes. I say, my lord, his case makes my case stronger, my lord.
Yes.
Our case stronger.
Stronger, not stronger than you. His case per se would be stronger in the
His
court,
case may be
not
stronger,
against you.
Not more than my case.
You are the strongest.
No, I am.
There cannot be stronger and stronger. It is,
Stronger.
you are strongest.
I am not the strongest, stronger. Because we have two orders from the landed courts below regarding possession, but they have only papers. Possession they had no. That is why I am saying that my case is.
They are not in position.
Possession they have taken isolatedly, but at that relevant point of time, in this 106 acres of land, they had no possession. It is I am submitting. I am submitting on the basis of court's order.
And that was upheld by the revision court.
Yes.
You are not in position.
My lord,
They come, they
This,
may come afterwards.
my lord, this grazing reserve comprises of 800 bighas of land. We are concerned with, my lord, 400 and odd bighas. And the question was, my lord, whether they have encroached our land. The finding of the, my lord, session judge, if we take that, my lord, they were not encroaching our land. But in our position, so far as our position is concerned, my lord, that has never been questioned, my lord, on the land that we are occupying.
Case was filed by your party. In that view, the order has been given.
What is the present policy, Mr. 2019? Okay. What is your name?
I am submitting.
Yes.
Admittedly, lands are government lands. But government has given them some lands. Out of those some lands, some portions have been given to us. It is the prerogative of the government. Government can do this. This is the law.
What about grazing land?
Grazing land may not actually when it is deforested already.
No, it's not. It's not forest. It's grazing.
The reserve.
It's not forest. It's grazing land. Grazing land. Community land.
When it is already done something in the interest of public, when a law is flexible, every law is made according to the situation. Sometimes agricultural lands are also made forest land. Lordship is our Kaziranga expansion is going every now and then. I have got some cases also. Agricultural lands have been included within Kaziranga National Park. So in this way, when the government has the right or power to include some lands as forest land, government has also power to deforest the same. So I think court should not interfere in this matter because that is
No,
the
those
policy-
powers
those
powers are governed by a particular set of laws. Reserving is one factor, de-reserving another factor. Can you de-reserve a forest land just like that? There are many formalities. It's not. You have to take sanction of the central government. It's not like, okay, we'll consider. Yes, what is your name? Our Gauhati. He is with you, Mr. Choudhury? Oh. heard Sri M.K. Chaudhary, Learned Senior Counsel, assisted by Sri R. Gohai in WPC 3550/2020. Also heard Sri M.U. Mahmood, Learned Counsel for the petitioners in WPC 7370 of 2023. Sri H. Sharma, Learned State Counsel, and Ms. G. Hadarika, Learned Revenue Counsel. The hearing is concluded. Judgment is reserved.
Highly obliged.
आदमी लिख दी बोले बेटे
I just few minutes back, I came to know that the respondent number 3, the municipal board has filed an affidavit.
Silchar.
Silchar municipal board has filed an affidavit without serving copy on me.
It cannot be. How do you file
Yes,
an affidavit?
because of there is some confusion in the cause list. Your lordship will find the counsel appearing for respondent number 6, Mr. S.P. Chaudhary. His name is reflected on the petitioner side. So
That's the problem, maybe. But I'm not sure whether copy has been served or not.
no, that
But
I have
then
checked that.
I
Mr.
assure you
Chaudhary-
that
Who is G.R. Datta?
I'm appearing.
7. And S.P. Chaudhary
Chaudhary was there.
for respond number?
He is for development authority. Yes.
Okay. And for government council, somebody has taken. A petitioner has not been served.
I have checked. I came to know from Mr. S.P. Chaudhary only that.
Okay, okay. Is have a copy?
My arrangement is correct, Milord. I just.
Okay, okay. There's some confusion. Okay.
Well, this is a matter which is illegal construction since 2021. And the municipal board has, after 5 years, have filed the
Affidavit.
Some urgency is there.
Yes, you suggested it.
Any day.
How much time will you have to go through, time you require to go through the affidavit?
Our expert.
No, my lord.
No, he might
24.
also like to file some
Yeah,
reminder.
yes, that is true.
Uh,
24th, my lord. Yes.
Can you do one thing? Tadhar, we'll have it after some time. You have a glance of this. If you say that you
I
require,
have seen, and this is in my.
then if you want time for rejoinder, we'll grant you time. If you think that you can submit on
In
behalf
fact,
of
my lord, I have gone through the affidavit filed by
Municipal.
Silchar Municipal Board. They have saying that the entire permission.
No, we are not on the contents. Will you like to file a rejoinder or you can argue on
yes, my lord.
rejoinder? Okay, we'll grant some time.
Yes.
How much time do you require?
1 week, my lord.
1 week, okay. Heard Sri A. Dhar, Learned Counsel for the petitioners. Also heard Sri S. Datta. Oh, no, also heard Sri Andas, Learned State Counsel. Another comma. Sri S. Datta, Learned Senior Counsel for the respondents 3 and 4. Comma. Sri, your name? Sri D. Mazumdar, Learned Counsel for respondent 7. Full stop. It appears that the Silchar Municipal Corporation has filed an affidavit, copy of which, however, could not be, was not handed over, was not furnished to the Learned Counsel for the petitioner, which has been done now. Full stop. Para. Sri Dhar, the Learned Counsel for the petitioner, prays for time to file a rejoinder affidavit. Full stop. Para. As Mr. Chaudhary, for whom?
I'm for the development of lesson number 6.
SP Chaudhary, upor respondent 6. That last up. As urgency has been expressed, list on. Yes, tell us a date of your convenience, all of you.
19th March.
19th March is okay, Mr. Dhar? 19th March, by which time? Rejoinder affidavit is required to be filed.
Obliged.
Item 6.
May I please?
Yes, Mr. Mohanto.
Lordship, petitioner here is the provincialized college.
You are a provincialized college.
Yes, my lord. And in this case, because petitioner is aggrieved by the action of the respondent in the withholding.
We can go for disposal of this matter. Mohanto? Yes.
Lordship, here the fact is that the petitioner college was established in the 1997, my lord. And government concurrence was granted in 2001. And thereafter, in the year 2013, college was brought into the provincialized mode.
13 you were provincialized.
Provincialized mode. And after that, my lord, since 2020, my lord, college also received permission and approval to start science stream also, my lord. 2020, my lord.
You got approval for
Start science stream, my lord.
science stream.
Yes, my lord. Let what happened, my lord, after establishment on 1989, my lord, 1998, my lord, that is 26/3/1998, my lord,
Yes.
Karbi Anglong Authority allotted 100 bigha of land, my lord, to construct the college building, my lord. Lordship will find the order at page 23, my lord.
Yes. What is the grievance?
Lordship, in this case, my lord, though land were allotted and possession was handed over to a petitioner, at the time of handing over possession, there is a pocket of land which was under encroachment, my lord. And after getting possession, my lord, petitioner were repeatedly represented before the authority to evict them and give the land without any encroachment. And thereafter, my lord, after a long time, they initiated the took step for eviction. Even 2 dates were fixed for eviction, my lord. And more than that, my lord, they collected money, my lord, due to paucity of fund, my lord.
For carrying out the eviction
Carry
proceeding.
eviction. And after fixing to date, my lord, then they suddenly withheld the eviction process, and till date, since 18, that was not carried out. You also will find the allotment order at page 23. my lord.
Let us see your prayer, Mr. Mohanto.
Because pair is mandamus, pair 1, my lord, a writ of Nessa mandamus at page 19, my lord. Directing the respondent to take appropriate step to evict the illegal encroacher from the land belongs to the petitioner college pursuant to the order dated 12/6/2018, that is Annexure 13, issued by respondent Karbi Anglong Autonomous Council, and the subsequent order dated 23/8/2018, Annexure 15, issued by the respondent of the commission, my lord. And thereafter, my lord, and similar, my lord, that is the lawsuit will find the page 23, the allotment order, my lord. And next page 24, that is the possession certificate handed over to the petitioner. There is 100 bigha of land, dag number 171. Under at village New Assam number 2, block 2 seat under Sariajan Moja in favor of the Karbi Anglong College, following cancellation of the allotment land to dairy farm as recommended by so and so in its meeting dated 21/3/1998. That is, I am reading page 23, my lord. And there is a condition, my lord, that allotment will be automatically reverted back to the council if it is not utilized for a purpose which it is allotted within 1 year from the date of issue of this order. And next page 24 is the possession certificate that was given to the petitioner college on 30/3/1998, my lord. And since there is and in the meantime, my lord, the land allotted to the petitioner was bifurcated in 2 parts because of some public good was constructed between the land. And these 2 parts was allotted with 2 different
dag number, that is land measuring 70 biga falls under one dag number 171 and 30 biga and other side that is 286 dag number. And since at the time of handing over possession, the pocket of land was under enforcement measure, and petitioner college repeatedly represented before the authority measure that enforcement be cleared and
Yes, Mr.
lawsuit would find and let me complete me. And thereafter, my lord, after mass long, my lord, page 31, my lord. Lordship, I'm sorry, page 29. That is the letter issued by additional deputy commissioner.
Yes, what is there?
It is issued on 18 August 2017, my lord. To Assistant Revenue Commissioner, my lord. May I read, my lord? With reference to the above, if I would like to enclose here a copy of the letter under reference received from the principal of Eastern Caribbean College, Soriajan, which is self-explanatory of the explanatory for information, and request to kindly take necessary arrangement for demarcation of land area allotted to the Eastern Caribbean College, Soriajan, and cause an inquiry into the matter of enforcement of the land belonging to the college. You are requested to fix a suitable date for eviction of the enforcer immediately from the land belonging to the college, as stated in the letter of principal to Occupancy. In this regard, you are requested to contact with OC Bukadan Police Station for eviction operation, and also contact the undersigned for deputation of magistrate for the above purpose. Action taken report in this regard may kindly be to the undersigned at earlier. And thereafter, my lordship will kindly turn to the page 31. Pursuant to that letter, Deputy Secretary, Department of Revenue, Karbi Alam, wrote to the Assistant Revenue Officer, regarding illegal enforcement. That this letter I am reading, I am directed to inform you that the authority of CARB has approved for eviction of encroacher in connection with the alleged enforcement of allotted land of Eastern Caribbean College, Soriajan, Caribbean Bhai, dag number 171, 70 biga, and dag number 186, 30 biga at village New Assam block number 1 under Gorjan Moja. Therefore, you are requested to take immediate necessary measure to carry out eviction process to the illegal encroacher as per list annex. I enclose observing all following. And thereafter, my lord, estimate was prepared, my lord. Lordship will find at page 32, my lord. Page 32, my lord. This is the estimate. Lordship will kindly
32.
32. This is the estimate prepared for eviction plan. Lordship kindly first paragraph in last line, my lord. They also prepare, they also have had the enclosure list, illegal enclosure. The enclosure list has already been submitted to the CARB authority. They know very well who are the enclosure. And thereafter, Lordship will find the letter dated written by Deputy Secretary at page 33. Lordship will find the estimate in page 32 that 1,41,900.
Correct.
This is the estimate prepared by the authority. And Lordship will find page 33. Since there they cited procedure fine, and accordingly by this letter, they requested the college authority to arrange the fund subject to reimbursement. That is the letter written by Deputy Secretary to the principal. Expenditure for eviction drive to illegal encroacher from allotted land of promotional. With reference to the cited above, I am directly informed that due to fund counts of CARB, the amount required for eviction amounting to be 1,41,900 could not be made available. In this regard, you are requested to manage the expenditure from your inn, subject to reimbursement in due course.
Okay, okay.
And lastly, thereafter, an assistant revenue officer wrote to the principal also, page 34, requesting to make arrangement. The similar line below. With reference to the letter as so and so, I have the honor to request to kindly to deposit the estimated amount, rupees so and so, only to the authority of Karbi Anglong Autonomous Council Depot for carrying out the eviction drive on illegal enclosure at the allotted land of Karbi Anglong Authority so and so. And pursuant to that two letters, that is page 33 and 34.
Yes,
College authority deposited the amount, Lordship will find it page 35.
30.
35. This is the letter written by Lordship, with reference to subject, I have the honor to submit here with the expenditure amount of rupees so and so for eviction drive on illegal enclosure from allotted land of Eastern Karbi Anglong College, Soriajan, to subject to reimbursement so and so. Please find enclosed here with a check bearing number so and so amount so and so. The college
Yes.
also deposited the amount. And after deposition of that method, Lordship will find page 37, CAG authority fixed a date method by this order method. Approval and date. That is, the order is 12/6/2018 method, as page 36. The authority of Karbi Anglong Autonomous Council Diffu is pleased to approve and fix the date to carry out the eviction drive of land of Eastern Karbi Anglong College at Soriajan on 19/6/2018 at 10 AM. That was the date fixed for eviction drive to vacate the land falling under allotted boundary of Eastern Karbi Anglong Soriajan. The assistant revenue officer Diffu will remain in charge and settlement officer CAG Diffu will remain overall in charge. And thereafter, my lord, page 37 letter came to be issued by Deputy Commissioner for rescheduling the eviction drive. It was fixed on 19/6 and by citing some reason, my lord. And after this letter was issued by the Deputy Commissioner to the Additional Deputy Commissioner for rescheduling the date for eviction. I'm reading, my lord, page 37 to the Additional Deputy Commissioner in charge Bukajan subdivision, subject detailment of a magistrate for eviction drive. It is informed that Department of Revenue CAG Bhai so and so has requested to detail magistrate for eviction operation to be carried out in the land of Eastern Karbi Anglong College situated at Soriajan on 19/6/2018. But said request would not be considered due to procedural responsibility like law and order, flood duty in general, and NRC duty in particular. The principal of Karbi Anglong College is now approaching this office to carry out the eviction drive as early as possible to free the land belonging to Eastern Karbi Anglong College from enclosure. It is therefore requested to fix the said eviction operation on 31st August 2018. DC had fixed this date for eviction. Further, you are requested to take necessary action for detailment of magistrate for the aforesaid eviction drive keeping licensing of with the concern and report compliance. And thereafter, pursuant to this order, Miller, next 38 order came to be passed by the Additional Deputy Commissioner, fixing, rescheduling the date for eviction.
No, that is not prior to, that is 23rd/8.
Yes,
After that order.
yes, Miller.
38 is subsequent.
Yes,
23/8.
yes.
Yes.
20, that is the order, Miller, in pursuant to a letter to so and so, Deputy Commissioner regarding detailment of law and order duty during the course of eviction operation in the land. Soriajan, Bukajan, on 38/8/2018, Sri Tahir Alam, SCS Executive Magistrate, and Sri A. Bemthoi Sanu, SCS Executive Magistrate, are hereby detailed as a magistrate on duty for the purpose till completion of enterprise. Even magistrate concerned official also little Miller. But and thereafter, Miller, eviction plan has been prepared. That is, Lordship will find at page 39, Miller.
Yes.
Lordship kindly see, have a look at page 39, my lord. This is the eviction plan prepared by Assistant Revenue Officer pursuant to the order dated 15/12/2017, my lord. So with reference to the subject and letter cited above, I have the honor to submit herewith an eviction plan for eviction to be carried out at the allotted land of Eastern Caribbean College on 31st August 2018 at 8 a.m. my lord.
Yes.
But suddenly, thereafter, nothing have happened, my lord. Authority fixed two date, my lord. One was 19/6/2018, and thereafter 31st August 2018. Petitioner college deposited the amount as requested by the authority, my lord.
Yes.
Nothing happened, my lord. The petitioner is a public institution, my lord, of the Caribbean Autonomous Council, a government of some situated, located within the jurisdiction of Caribbean Autonomous Council. They have some responsibility also. This is your their institution. But despite the land being allotted, they have been their position has been granted hand over to the with encroacher, and that has then repeated request, my lord, and the due date has been fixed, but till that they have not carried out this person. That's why, my lord, I'm before the lordship and lordship. As for affidavit filed by the Caribbean Autonomous Council, the process was initiated under Rule 18 of Rule 18 of the rule frame under 1886, and as per Section 165 of Assam Land and Regulation 1986. But despite of that, that has not been carried out. So my humble submission is lordship will find the affidavit at is 41 onward, paragraph 9, my lord. They admitted that they initiated the process for eviction, my lord. Kindly have a look at page 46. This is the affidavit filed by the restaurant number 6.
Please read.
Paragraph 9. Rule 18 of the settlement rule frame under Assam Land and Regulation provide for ejectment. 18 to empowers the authority to evict the person who entered into the possession of an estate or a land reserved for public purposes, over which the person has no right to acquire of land holder or settlement holder, and the person has no bona fide claim of the invoked. Settlement Rule 18(3)(a) empowers the authority to evict the unauthorized occupant by issuing notice to the vacant land. Paragraph 10. The Section 165 Assam Land and Revenue Regulation 1886 provide for ejectment and eviction. Section 165(3)(a) provides that in the case of periodically settled land, person who have entered occupation without valid authority from the landholder, or whose entry or occupation is or has come about in a manner inconsistent with the provision of chapter, shall be liable to be. Section 165(3)(b) provides that such eviction will be proceeded by service of notice requiring the occupant and to remove all the buildings and other construction erected and raised within the period of 1 month. But from this affidavit, it appears that the step taken by the Caribbean Authority, as I've submitted, were taken under these two provisions. Lordship will find that paragraph 11, they have here stated that due to some procedural implication, that process could not be completed. Paragraph 11. The authority of Caribbean took steps to evict enforcer from dock number 71, so and so under Bukajan, but due to certain procedural implication, the eviction could not be carried out. So there was a mobilization of people, tools, equipment by incurring expenditure for that purpose. That expenditure was incurred by the petitioner. So here may let's take another stand at paragraph 8. So we will kindly have a look again at allotment order, Miller.
Paragraph 8,
8.
page
8. Page
45.
45. The college authority utilized the land measuring 30 bigha of land for the purpose of college by constructing building on said land. The allotted land was subsequently bifurcated into two separate drag were created. Land measuring 30 bigha carved out from 171 are separately numbered as 286. The remaining land 70 bigha of land 171 have not utilized by the college authority within 1 year from the date of allotment of for the purpose for which it was allotted as per allotment order dated 26/3/1988. The land deemed to have been automatically reverted back to the council. Also, we kindly have a look at this 23 again, Miller. There is a condition, Miller.
Page
Page 23. That is the allotment order. There is a condition that the allotted land was to be.
Yes, we have seen that.
But my stand is that since day one, at the time of handing over position, the pocket of land around 40 bigha Miller under enforcement, and petitioner college repeatedly pursuing with the before the authority for clearing that land by conducting eviction drive, Miller. But that has not been carried out, Miller. That's why we denied that we not utilize that said land. Now, our affidavit, I have given a cert, Miller. Lordship will find at paragraph 6, page 54. 54. Out of 70 bigha under dock number 171, we have one position about 26 bigha because other portion of land under enforcement, and we have
Page you are referring to
54 million. That is a cert.
of your reply affidavit.
Yes, Lordship will kindly have a look at the 58 million. Long reply. Here we take a stand that land was under enforcement, and Lordship will kindly have a look last paragraph of this petition. As stated, already stated, out of 70 bigha of land falling under dock number 171, approx 27 bighas of land are under active possession of the petitioner college, and the same has been utilized for multiple purposes which are as follows. Next, we have I have given a table, Miller. College playground 10 bigha, girls hostel under construction 5 bighas, proposed boys hostel 30 bighas, proposed indoor stadium 9 bighas, total land 20 bigha is active position. That is therefore, Miller, it is not true that we have not utilized the land under land falling under dock number 171. But remaining portion, Miller, approximately 43 bigha, as enclosed by in and around 13 to 15 family, Miller. But in present time, government has have been taking step to evict the illegal land to serve from the government land. But this land, in spite of this land, belongs to allotted to the petitioner college, which is the provincial college located within the jurisdiction of Karvelang Autonomous Council. They have not. I don't know why they show
Okay.
so much of.
Anything else?
So there's no prayer. So Lordship, humble prayer, but the eviction by process which was initiated by authority should be directed to be complete images.
Yes.
Look into annexure to page 23, the allotment order. The allotment order is specific, my lord. It was issued on 26/3/1998, my lord. That this allotment of land will automatically revert back to council if it is not utilized for the purpose for which it is allotted within 1 year from the date of issue of this order. Admittedly, my lord, the petitioner failed to utilize the land, my lord, for the purpose of the college, my lord. That is the admitted position in the affidavit reply, that they have not utilized that land. If the land is not utilized, my lord, that is automatically reverted back to the council. And so before taking into account the, my lord, eviction drive, my lord, so we have to, the council is required to look into the persons who is, my lord, settled, who is the, occupying the particular land, my lord. Land has already, my lord, divided into two parts, my lord. One part is in the position of the petitioner, while another part is in, my lord, without in any position, my lord, and if some peoples are there. And annexure 3, page 24 is the, my lord, possession certificate. We have handed over the possession to the petitioner on 33/1998. If the petitioner failed to protect the, my lord, their land, my lord, after within 1 year, and after almost 18 years, my lord, they woke up in 2017 and submitted an application for eviction of the persons, my lord. Autonomous council has the power to evict, my lord, but before taking to eviction drive, the persons is required to be taken into consideration all aspects of the matter, my lord. So it is open for a petitioner, my lord, to approach the authority of the council, whether they want, my lord, how they can want to utilize the land. They have to submit a plan. They have to submit an application for.
Your council is so poor that you take a loan from the college.
At that time, my lord.
Your council is so poor.
My lord, at that time.
KAC is supposed to be one of the richest council.
In 1998, my lord.
Now, what are you doing? You are supporting some private person against a public institution.
My lord.
That is your stand.
My lord, at that time, my lord.
How soon can you get the eviction done?
My lord,
How soon can you get the eviction done? How soon are you going to refund this amount? And how much cost are you going to pay?
my lord, lordship has passed the
Three
order.
questions from this court.
My lord.
First, how soon can you evict the encroachers from this college? When are you going to refund this amount, which has to be done by you? And how much cost you are going to pay for this litigation? Three questions. We want your response. Tell us. Tell us.
No, my lord, I have to take instruction.
No instruction. We are not going to take. We are not going to. After your submission that they have not taken possession, when you have failed to make the land encroachment free, and you are making this kind of a submission.
That is, my lord, that is.
At that time, why didn't you say that you have woke up after 17 years?
My lord.
You asked for money from a college to carry out eviction. Then you go on postponing after postponing. Procedural defect. Something happened. Some law and order.
My lord.
We know what is going on, Mr. Chotia.
My lordship
Don't.
What is
Mr.
going on
Chotia,
here,
don't.
my lord, at this stage, my
Please
lord,
do not
lordship
mind
knows-
we being harsh on you. On you means we are on the council.
My lord. My lord, lordship knows what is going on in their council, my
So
lord.
we'll pass
In the
appropriate orders.
council, my lord, in the area, my lord.
We'll pass appropriate orders.
Pass
It's a
appropriate orders.
it's a college.
My lord,
On your own wisdom, you have given 100 bighas.
my lord,
There
if
was
they-
encroachment.
If they, when the allotment was in 1998, if they fail to utilize the land, some people.
How
my
do
lord,
you utilize when it is encroached, when there are encroachment?
What is that part?
Some right thinking
Lord,
person
only does-
had the guts to come to the reach the authorities.
My lord, lordship.
From
look
98
into
to
the annex
97,
statement, my lord, any document annexed in the repetition.
Lordship,
so that-
kindly have a look, page
Mr.
25.
Mahanta, will come to you, Mr. Mahanta. Let
Page
him complete.
25 below. Page 25 second paragraph.
In 1998, land was allotted to
Yes.
the petitioner, my lord. And it is a condition that if they fail to utilize the land, it will be automatically reverted back, my lord. From 1998, when the possession was handed over, if the persons, it is a factual part required to be decided, how the encroachers, whether it is on the, how they encroach the land to the position, my lord.
Mr.
That
Chutia,
is a
we,
factual fact, my lord.
Mr. Chutia, we would have given you due weightage in this. But when they had applied for making the land encroachment free, you acted.
My lord.
You said we have fund crunch. You allowed us the fund. Fund given. You give one date. Nothing done. You give another date. Nothing has been done. After taking that stand now, can you say no? You are too late in coming to the to coming.
That is not the submission. I'm not just pointing out that, my lord. So what is the, if the lapses on the part of the petitioner?
No,
whether
that submission will not be applicable.
My lord,
If in the year 2018, you take a step to make it eviction free,
my lord.
the question of deemed reversion will not come.
Technically, my lord, we have to issue notice to each and every individual.
What
my
have
lord.
you done all this time?
My lord, it is required to be issued, my lord. Lordship will look into another aspect, my lord.
And let us
Whether-
see 18.
18.3, my lord.
18.3, let's
When
see.
the land was allotted to them, my lord, and what is the duty of the petitioner, my lord, to, my lord, to apply
See,
for.
petitioner is not a private person, it's
My
a
lord,
college.
my lord,
With that aspect,
Yeah.
more than the court, it is for you to consider.
My lord,
That is a college which was allotted land, but none other by you.
my lord.
Nobody else has allotted
My
land. You have allotted land.
My
It's
lord,
it's your joint responsibility
My
to
lord,
have an academic atmosphere, the land
cooperation,
enforcement.
my lord, the eviction can be carried out in cooperation with both the sides, not from the either one side only, my lord. Both the sides.
They are not cooperating.
My lord, they should also come. Who are the persons occupying the land? Who are those
You-
people, my lord?
You have given a list.
My lord, this they have submitted. My
No,
lord,
no,
list.
it's your
My
list.
lord, they have submitted that list. We have forwarded.
We do not know.
My lord, these are the
This-
factual part, my lord.
This
So-
list has got an
My lord,
official stamp.
Before taking eviction, my lord, petitioner is also required to cooperate the persons who are occupying the land and how they are occupying the.
May not be an acceptable submission. May not be an acceptable submission.
Appropriate order, lordship may pass the.
Yes, anything, Mr. Das? Yes. See, we are dealing with a college. Just remind, before making any submission, public interest is involved. College is before us. There is no dispute with the allotment of the land. The prayer is very innocuous to make the land encroachment free. That we are considering, nothing else.
Only on his own document. ma'am.
Yes.
My lord, if your lordship come to page 25, my lord.
21,
25, ma'am.
25. Yes, please.
Second paragraph, it may be kindly noted that prior to handing over the plot of land to the college, some families is already settled in the said plot. The
Prior
college-
to.
Yes.
Yes, ma'am. Let's,
No, that is the standard of principle.
Yes.
I'll just make it submission.
That is the
If your
standard.
lordship come to the date of this application, 6/7/2007,
Yes.
and page 23 says, my lord, within 1 year, my lord.
Hmm.
Just making a submission here. Within 1 year, means he has got knowledge, it's prior to the settlement, my lord.
See,
He has.
Mr. Das, see, a college is a legal entity, but if we leave the veil, it depends who is running the college. Some principal may not be very interested in making the land encroachment free. Somebody has taken a step to make it encroachment free, and he has noticed that lands were there. They have. You may be right in contending. Even Mr. Chotia, there is no difference in the aspect of law that if you do not utilize this land within a period of 1 year, it gets reverted back. But just consider from the practical sense, 100 bigha for a new college.
Yes, at the time what my lord, it was.
And Mr. Mahanta, just have patience. You're interacting with Mr. Das. And college doesn't mean that the entire area will have construction. There will be playground, there will be open space. So in an open space and in an which was lying vacant, the aspect of encroachment is something very, very, you can imagine what is it.
Absolutely correct. My only submission, my lord, with page 23 and 25, my lord.
Hmm.
Page 23 says within 1 year. Now they have taken off from in 2007.
Hmm.
Had it been within 1 year, my lord,
Um,
that is my submission. my lord.
Yes. 25. Well, I will just come to one point. Just a minute.
Otherwise, my lord, it's a public interest, my lord. We do.
See, Mr. Das, there is a very simple answer to, not a query, to your concern, that after taking possession, they have come to notice that some people, some families have started residing. This,
No, my lord. It says prior to my handing over the land, some families had already settled in the said plot.
yes, prior to handing over, so this was raised in the year 2007. Now, everything, whether it is prior to or after that, you kindly come to the steps taken by the council in the year 2017. 17, they could have very well said, we cannot take out eviction. You have lost your right. After expiry of 1 year, you did not approach.
Money has also been deposited.
They went to the extent of, we can understand family. And there of course is a line that you'll be reimbursed. But that is also very embarrassing kind of a situation that you will ask money from the,
I'm just putting out the
okay,
factual facts.
please write.
Also believe that if the petitioner has the knowledge that certain people are residing there, they should also be made a party that it should they take and also respond. So before taking the eviction.
Not at all required, not at all required. We are not going to give any leverage to encroachers, illegal encroachers, making them parties in a proceeding. And that too for a college land. Had it been a private dispute, matter would have been different.
In respect to the forest land, also Supreme Court has passed the order regarding to take into account all these aspects.
It is a matter of astonishment that a college has to approach this court invoking its extraordinary jurisdiction for making the land allotted to the same encroachment free. Full stop. The relief claimed in this petition reads as follows. Kindly quote the prayer. Okay. Prayer, page 20, 19, quote all the prayer, 1920. Para. As per the facts projected, comma, the petitioner is a provincialized college which was established in the year 1997. Full stop. The college was allotted 100 bighas of land wide and order dated 26/3/1980, 1998 or what? 98. 98. And the same was followed by handing over possession wide certificate dated 30/3/1998. Full stop. It has been contended that in the year 2013, the college was provincialized and subsequently approval was also granted to start the science stream. Full stop. The dispute, as indicated above, no, don't say dispute, the issue in this case, which has been indicated above, is with regard to the aspect of making the land encroachment free. Full stop. The land in question contains of two DAGs, namely DAG number 171, comprising of 70 bighas, and DAG number 286, comprising of 30 bighas. Full stop. When the principal who was acting, who was there in the year 2017, had noticed that no concrete steps were taken to remove the encroachment, comma, the authorities in the Karbi Anglong Autonomous Council were approached, which led to the additional deputy commissioner to issue a communication dated 18/8/2017 to the assistant revenue officer to take steps for removal of the encroachment. Full stop. The revenue department, KAAC, wide communication dated December 2017 had approved the eviction process. And on 27/12/2017, an estimate of the cost involved was also made, which was rupees 1,41,900. Full stop. The Revenue Department thereafter issued a communication dated 15/3/2018 to the college stating that there was fund crunch and therefore the estimated cost was to be arranged by the college, which, however, would be reimbursed. Full stop. The said communication was reiterated by the Assistant Revenue Officer via communication dated 17/3/2018, directing the college to deposit the amount. Full stop. The amount mentioned above was accordingly deposited by the petitioner college via check on 19/3/2018. Full stop. The authorities had accordingly fixed the date of eviction as 19/6/2018 via a communication dated 12/6/2018. However, on the fixed date, the eviction process could not be carried out, and via a subsequent communication dated 21/8/2018, the date was refixed on 31/8/2018, citing some reasons. Full stop. Accordingly, an order was passed by the ADC on 23/8/2018, fixing the date of eviction as 31/8/2018 and had given all necessary instructions. Whereafter, the Assistant Revenue Officer on 28/8/2018 had prepared an eviction plan. Full stop. However, even on the said date, no action for eviction was taken, and the matter remained as such. Full stop. Having no other alternative, the petitioner college had approached the chief executive member via a petition dated 26/9/2022, praying for an urgent action for making the land eviction free. Full stop. It was also pointed out that the eviction process which was undertaken was postponed, and thereafter no action has been taken. Full stop. I have heard Sri M. Mohanta, learned counsel for the petition. I have also heard Sri N. Das, learned state counsel, and Sri J. Chutia, learned standing counsel, KAAC. You are also there, madam? Director of Higher Education. And madam? Okay. Miss G. Hazarika, learned standing counsel revenue, and Miss P. R. Mohanto, learned standing counsel higher education, are also present. Where? Sri Mohanto, the learned counsel for the petitioner, has submitted that the entire approach of the petitioner to make the land allotted encroachment free is bona fide and on public interest. Full stop. By drawing the attention of this court to the allotment order dated 26/3/1998 and the possession certificate dated 30/3/1998, the learned counsel has submitted that there is no dispute to the aspect of such allotment. Full stop. He has submitted that After such allotment, comma, activities were carried out for utilization, full stop. However, in course of time, comma, it was noticed that there were encroachment, illegal encroachment, full stop. He has submitted that though there was a stipulation in the allotment order that the land has to be utilized within a period of 1 year, comma, the land being a huge one comprising of 100 bighas, utilization can be done only, utilization would be possible, utilization would not only require construction on the entire plot of land, as parts of the land are also required to be kept vacant for playground and other activities. Full stop. Be that as it may, he has submitted that on approach of the college to the authorities, steps were indeed taken for removal of the encroachment. Full stop. He has highlighted that after the estimate was prepared for carrying out such eviction, comma, due to fund crunch, even the amount of rupees 1,41,900 was deposited by the college to carry out the eviction. He has submitted that for reasons which does not appear to be germane and relevant, comma, the eviction process was postponed on 2 occasions, in spite of the fact that an order was passed on 23/8/2018 by the ADC, refixing the date, and an eviction plan was also prepared. Full stop. He has submitted that it is the duty and obligation of the KAAC to make the land encroachment free so as to ensure that a healthy academic atmosphere prevails and the purpose of such allotment can be achieved to the fullest. Para 3. Mahanta of the Learned Council has also drawn the attention of this court to the affidavit in opposition filed by the respondent number 6 on 10/8/2023. Full stop. Specific reference has been made to the averments made in paragraph 11 of the affidavit in opposition, wherein certain procedural implication was stated to be the reason for postponing the eviction process. Full stop. He has also submitted that the aspect that 70 bighas of land not being utilized cannot be said to be a reason to bring in the deemed provision of reversion of the land, inasmuch as the authorities had taken active steps for making the land eviction free in the process initiated in the year 2017. Full stop. He has also drawn the attention of this court to the affidavit in reply filed on 29/8/2025, comma, more specifically, the averments made in paragraph 6, in which the land which has been utilized has also been given in a tabular form. Full stop. For ready reference, comma, the relevant part of the averments are extracted herein below. Page 53, table এখন আছে আৰু 54, 53, 54. The learned counsel for the petitioner accordingly submits that appropriate direction be given to the respondent authorities to make the land eviction free, so as to ensure that a better academic atmosphere prevails. Para. Per contra, Sri J. Chutia, learned standing counsel, has submitted that the land was allotted in the year 1998, and there is no dispute to this proposition, to this fact, full stop. He has, however, hastened, HASTENED, hastened to add that there was a condition attached to the allotment order that if the same is not utilized within a period of a year, the same would get reverted to the council. Full stop. He has submitted that the possession certificate dated 33/1998 would show that possession of the entire land in question was handed over. Full stop. He has contended that no steps whatsoever were taken by the college to initiate any process for eviction. And after a long duration, in the year 2017, a such step was taken. Full stop. He has justified that though the authorities had taken steps for carrying out an eviction process, there were genuine reasons for which the same had to be postponed. There were genuine reasons postponed, which include the procedural aspects. He has also submitted that for such eviction process, cooperation of the party seeking eviction is required, which was lacking. Para. 3. And thus, learned State Council has submitted that in one of the communication of 2007, the petitioner has the communication issued by the petitioner college dated 6/7/2007. It has been stated that prior to handing over of the plot of land to the college, some families had already settled in the said land. Correct? He has therefore submitted that it was very much within the knowledge of the college, of the enforcement, and there has been an undue delay in approaching the authorities. Full stop. Para. Sri Mahanta, the learned counsel for the petitioner, in his rejoinder, has submitted that the aspect of utilizing the entire 100 bighas of land within 1 year is not a feasible. No, don't say like this. In his rejoinder, has submitted that the defense made by the respondents of the condition attached to the allotment order dated 26/3/1998 cannot be put into application in a mechanical manner, as the land in question is a huge area of 100 bigha, which has been allotted to a public institution. Full stop. He has also submitted that the defense taken in the context of the letter dated 6/7/2007 would is not acceptable in as much as in the said communication, it has also been written that the college authorities were time and again reminding the KAC for the steps to be taken for eviction, which was not done. Full stop. Para. The rival submissions have been duly considered and the materials placed before this court, including the affidavits, have been carefully perused. Full stop. Para. As indicated above, the prayer in this writ petition is to take steps for making the land allotted to the petitioner college encroachment free. Full stop. Para. A reading of the material on a perusal of the materials before this court, there is no doubt with the aspect of the bona fide and the involvement of public interest in this present petition, which is instituted by the college. There is no dispute to the order of allotment of 100 bighas of land wide order dated 26/3/1998, followed by the possession certificate dated 30/3/1998. Full stop. There is the learned counsel for the respondents have tried to raise two issues, namely the delay in approaching this court, and secondly, the aspect of the condition attached to the allotment order dated 26/3/1998, requiring utilization within a period of 1 year from the date of allotment. Full stop. As regards the issue of delay, the said aspect has to be considered considered on case-to-case basis, depending on the facts and background. Full stop. As mentioned above, the petitioner herein is an educational institution and not a private body. Full stop. Secondly, the aspect of delay which was available to the respondent authorities to raise was not done when the initiative was taken in the year 2017 to remove the encroachment. In fact, the initiation had culminated into orders passed by the appropriate authorities on numerous occasions. Full stop. This court has also noticed that that an estimate of cost which would be involved for the eviction was also made, amounting to rupees 1,41,900, and the same had to be paid by the college on the pretext of fund crunch. There is no dispute to those aspects of making such deposit by the college, whereafter two dates were fixed, namely 19/6/2018 and 31/8/2018. Full stop. So far as the second date is concerned, an order was passed on 23/8/2018 by the ADC, followed by an eviction plan by the Assistant Revenue Officer on 23/8/2018. Full stop. No discernible reasons have been cited by the respondent authorities as to why the eviction could not be carried out, except the plea that it involved procedural aspects. Full stop. In this connection, the averment made by the respondent number 6 in paragraph 11 has been noted, wherein it has been categorically stated that due to certain procedural implication, the same could not be carried out. Full stop. The aforesaid defense on the part of the respondent authorities cannot be accepted, more so in view of the steps already taken, which in view of the conscious step already taken in the years 2017-2018. Para. As regards the second issue sought to be raised regarding utilization of the land within a year, comma, this court is of the view that the land allotted is a huge one of 100 bighas, which is not to a private individual, but to a college. And as of college full stop, it is a common knowledge that when such land is allotted to a college or a public institution or any educational institution, comma, the entire land in the education construction would not be done in the entire plot of land, and considerable area has to be left vacant for playground and other activities. Full stop. Though there is some dispute as to when the encroachment had taken place, that is, whether it was prior to the allotment or after the allotment, comma, the very fact that the administration had taken a conscious decision to carry out eviction in the year 2017, which had suddenly come to a standstill, does not inspire any confidence. Full stop. It is not the case of the respondents that there were any orders from any court to prevent such eviction. Full stop. Para. In that view of the matter, comma, this court is of the considered opinion that the petitioner is able to make out a case for interference. Full stop. This court is also perturbed by the fact that a petition of this nature had to be filed for a purpose which is intrinsically connected with public interest. That is making an area allotted to an education institution encroachment free. Full stop. Para. In view of the above, comma, the writ petition stands allowed by directing the respondent authorities, more particularly the Karbi Anglong Autonomous Council, to take immediate steps for carrying out the eviction and make the entire area allotted to the college encroachment free. Full stop. The council is also directed to immediately reimburse the amount of rupees 1,41,900 to the college with a further interest at the rate of 18% from the year 2017. Full stop. The KAC is also required to pay cost of rupees 1 lakh to the college for as litigation expenses. Writ petition stands allowed.
Item 7.
My lord, this matter may kindly be taken up on 17th of this month.
What is the matter?
It is regarding the sales tax man,
Sales tax.
GST. It is the sales tax.
Why not today?
Today, my lord, because in second half it will take time, my lord. And in second half I would be otherwise.
Second half, you have to go somewhere.
Yeah.
How much time will you require, Mr. Bhatti?
At least 2 hours.
2 hours. You will not take 2 hours. You are very fast. Half an hour.
Half an hour, I cannot.
Half an hour. See, we have read the brief. Nothing, there's nothing. Facts, there is nothing. So some law points you may argue, which Mr. Kyle will reply. You try your luck. Okay, we'll have it on another day of its convenience.
Let it be on 17th.
17th. 17th? After 20. Yes, tell us the date of your...
After 20.
24, okay. Sri O.P. Bhatti, learned counsel for the petitioner, praise for an accommodation. Also heard Sri S.C. Kyle, learned CGSC. Full stop para, as agreed to by the learned counsel for the parties. List on 24/3/2020.
Okay.
Item 8, yes, Mr. Borgo.
May please, Your Lordship. Lordship, at the very outset, I would like to state that respondent number 7 has expired, my lord. We are to substitute, my lord. On the last occasion,
You had made this prayer on 29/8/25.
Yes,
Thereafter,
my lord. The information was also supplied, my lord. But due to my inadvertence, my lord, I had somewhere misplaced the information.
but that was in 8. You have been abated now. If you go over the principles of, it's been abated.
Respondent number 7 has expired.
Now 7, it has been abated.
That's what, my lord, I will file the requisite applications, my lord.
You have to file not only substitution,
Delay condonation as well as abatement.
abatement,
Yes, my lord.
setting aside abatement.
My lord, due to my inadvertence, my lord, I lost.
Yes, Mr. Sharma.
Respondent, I am to file the affidavit, but because of non-taking of receipt, state for the application for the regular.
Okay, in the meantime, you also file affidavit. Okay.
Because we file the common affidavit.
For 7, it might be abated, Mr. Barua. Heard 3, your care, Barua.
Care, bro.
Heard 3 care, Barua, learned counsel for the petitioners. Also heard 3 Andas, learned state counsel. And 3 K. Sharma, learned counsel for respondent 4, 5, 6, 8, and 9. Full stop. Para. By referring to the order dated 29/8/2025, Sri Barua, the learned counsel, has submitted that though steps were to be taken for substitution of the respondent number 7 who had passed away, such steps could not be taken due to inadvertence. He accordingly prays for some time to file appropriate application. Full stop. Para. You can file it in the meantime because it will be better to square the respondent number 7. For you, it will be continuing. List after 2 weeks. List after 2 weeks to enable filing of appropriate applications as bracket may. In the meantime, pleadings may be exchanged by the other respondents. Now you file your affidavit 7 for 7. If it's abated, there is no question because it's matter is of 2023.
On last occasion, the forest department took time for filing affidavit. Thereafter, they, my lord.
Forest Department. Yes, who is for Forest? Mr. Das, please, Forest Department. Forest.
My lord, my case is, my lord, that there was a civil suit, my lord.
Who are you?
I am the, my lord, pata holder. I am the pata holder, my lord. I have purchased the land by registered document, my lord, and I am possessing, my lord, since 2006, my lord. Thereafter, my lord, off and on, since 2006, my lord, the forest department claiming this is the reserve land, my lord. And we have made representation for demarcation, everything. There was some process was there, my lord, but that was not done, my lord. Therefore, we have instituted suit, my lord. Declaration that right title interest and injunction, my lord. The suit was contested by the Forest Department, my lord. They also adduce evidence, my lord. After discussion, my suit was decreed in my favor, my lord. The Forest Department preferred appeal, my lord. The appeal was also dismissed, and it is judgment was declared in my favor. And my lord, in the year
Mr. Gogoi? Yes.
So, my lord, thereafter, my lord, again, is a new set of officers. They again enforce our land, my lord, and call the treason, my lord. So we have, my lord, filed this petition for our right, claiming right and restraining them. So at this stage, my lord, interimus.
Well, grant me some time, I'll respond to it. Next.
But if the issue has been settled by a civil court, which has attained finality in the appeal, you cannot reopen the issue. Either you get that order interfered with by a higher court, because you cannot just. You bring your brief, we'll try to dispose this of.
Well, I'll bring out.
After, at 2 o'clock. There is nothing to be decided, it has been decided already. What Mr. Deka has submitted, had it been some contentious issue, he says that you say it is forest land, they say it's Miadi Pata land which he had purchased. Let us for the time being assume that it's a disputed land, but the dispute has been resolved by a competent civil court, attained finality in the higher court in an appeal. And thereafter, same plot of land, can you again claim that it's forest land? There's a decree.
Well, I understand, there's a decree.
You go through at 2 o'clock, you have some time, okay? Mr. Deka, at 2 o'clock, we'll dispose this.
Yes.
Of course, we are proceeding on what you had submitted.
Yes.
If there is something else, then
Yes.
matter will be different.
Yes.
But what you have submitted, we are
Yes.
will be proceeding. Okay. Yes, Mr. Day.
My lord, please. My lord, this is a case where I am in I am in the business of construction of roads, which have been used by the public authorities generally, my lord, and I am registered, having registered office in Punjab. That is an admitted position on record, my lord. Now, my challenge, my lord, is of three folds.
Yes.
Yes, ma'am. So my challenge is of threefold, my lord, if I may put it in this way.
A challenge, you are aggrieved by something?
Yes, my lord. I'm sorry, my lord. I'll take this one. I will put through the records. My lord, the impugned order is passed in the page number 61, my lord.
We'll go to it. What is your challenge?
Yes,
Just let us know in brief, then we'll go in detail.
My lord, please.
What is the challenge? What is the grievance?
My lord, the grievance is there that I am being imposed with an illegal tax demand of 5 crore 31 lakhs 66,354.
On what head?
On the hands that I have not paid service tax. I was supposed to pay service tax and I have not paid.
On the head of service tax?
Yes, my lord.
Okay.
And under the heads of the sections are quoted, I'm not troubling this enough. Along with that, there is a penalty of like amount. And also there is interest and other heads are there where some additional amounts of 40,000, 30,000, such and such amounts have been imposed upon me, my lord. And which I have challenged by this petition before this honorable court. The order, if my lord, if I...
Yes, yes. Yes, Mr. Kyle. Challenges to imposition to a demand of service tax.
Yes. In a section.
Why is he not entitled?
Because appeal is he can go for appeal also.
No, that is on the procedural aspect. On merits, what do you say?
It's the duty of the petitioner to satisfy the executive authority that he is entitled to the exemption. That he failed to do. He submitted some documents that are on the surface.
Will you like to file an appeal?
My lord, I will satisfy, my lord, that the issue of jurisdiction is involved, my lord.
Okay.
I am an entity based out in Jalandhar, Punjab, my lord.
Okay.
And the service tax, it is not service tax. The authorities has not taken notice under service tax, my lord. He has taken on notice a GST commissioner of Dibrugarh, my lord, has taken a notice of an issue which was exclusively covered by Jalandhar Commissioner. Now I will show that particular page, my lord, and probably then my lord will allow
Okay, you are on the issue of jurisdiction of.
jurisdiction. First issue is on my jurisdiction, my lord. Then the second issue is on, my lord, whether I have submitted the other documents. That
No,
I will
if you,
satisfy.
if you are able to succeed in your first point, then it's not required to go
My
into the
lord.
merits. You
70th
said
check-
that even if there is any issue, it has to be the commissionerate at Jalandhar,
Jalandhar, my lord.
not Dibrugarh.
Not Dibrugarh, my lord.
Okay, we'll hear on this. Yes, what is it?
My lord.
Yes, Mr. Are you, what is your, this, on your take on this jurisdictional issue?
See, the demand notice was issued in Dibrugarh because they are having their petition delivery.
Who's having?
Petitioner. What's my place to say?
Work was done where? Work was done?
Dibrugarh district. Dibrugarh Commissioner.
What kind of work? Construction of road?
Yes, that is there. They may be entitled to exemption under mega notification. But what's it, it is their duty to satisfy the authority they are entitled to. That is settled by the Honorable Supervisor, acknowledged by our High Court.
What is the difficulty in filing an appeal?
My lord, I will satisfy, my lord. My
So
first,
even if you file, even if you succeed in your first on jurisdictional, the issue, on merits will not be resolved. It will still be carried out. Maybe not by this directorate, some other commissionerate. But issue you have to fight it out. So if you are willing, we can give you liberty to file an appeal.
my lord, I appreciate, my lord, what is following from this honorable court, my lord. What has happened, my lord, in this case is this, that the issue of jurisdiction was raised by the noticee, while before the AO, by the assessing authority, but that issue has not been touched upon by him. Rather, he has, in a convoluted manner, he has returned finding
No,
on
that
something
is
else.
what Mr. Dev were trying to express.
Then my seventh, I have to, tell
Then
my lord,
if you succeed on jurisdiction issue, okay, then we are not going to enter into the merits. Then we have to approach the appropriate jurisdictional commissionerate or director, whichever. On the issue on merits will still be open.
my lord, if I may propose something else, then
Yes,
this
yes,
is,
please.
my lord, if the matter is remanded back to him to decide the issue of jurisdiction also, because there is a precedent of our High Court also is there. That, my lord, I have quoted of any logistics. But this honorable court had remanded back on the similar issue, and on the issue of exemption was also.
No, we go
considered.
one step further.
Well, the
We go
problem-
one step further. In the remand or otherwise also, we hold that you have a point of jurisdiction.
My lord,
Thereafter, what will happen on the merits, on the demand?
if
He'll not be able to adjudicate, but it cannot be left like that. Somebody will have to adjudicate.
then, my lord, it has to be sent to the Jalandhar commissionerate, my lord. If that has been sent to Jalandhar, I am also amenable to that also, my lord.
Then let it be done by Jalandhar.
Let the Jalandhar issue.
Not to come to page 50. So,
Then let us hear then, Mr. Dev. Let us hear you. Yes, start.
My lord.
Let us hear the issue, Mr. Kyle. Have your seat. Let him.
My lord. My lord.
Yes.
My lord.
Who are you?
My lord, I am the company.
You're a company.
Yes, my lord.
You're having your registered office at Jalandhar.
Jalandhar, my lord.
Not Jalandhar.
Yes, my lord.
Batala.
Batala, my lord. That, my lord, will find in page number 26, my lord.
Batala is in Jalandhar.
My lord, Batala is in, my lord, Punjab, my lord.
Punjab, that we know. You are saying Jalandhar.
Jalandhar is the commissionerate, my lord. The jurisdiction commissionerate is Jalandhar, my lord. My page number 26 is my company master data, my lord. I have taken a printout from the ROC.
Okay.
My lord will see on page number 26. My registered office at village Bahadurpur, GT Road, Batal, and Gurdaspur.
Batala.
Batala, my lord. Page number 26.
Okay, that was good. Then what do you do? Your work comprises of construction of roads.
Is basically, my lord, I'm in construction, repair, alteration, maintenance, and revocation of public road. para number 2 in page number 6, my lord, I mentioned what I do.
Yes.
And precisely for that reason, my lord, I am exempted under the mega notification. That, my lord, mega notification will, my lord, will find at page number 27. And under the head of the 13 services, page number 30, my lord, will see that services which are provided by way of
Page number
30, my lord.
30.
Yes, my lord. It starts at page number 27, the mega notification. It starts at page number 27, my lord. The
27.
notification starts at page number 27.
What is the date?
My lord, date is 26/2012. Notification number is 25/2012-ST,
26.
dated 26/2012. my lord.
Okay.
In
This is-
exercise of the
This is
power.
an exemption notice.
Yes, my lord. There is a mega exemption notification under the service tax, the S12 service tax, my lord. Now, my
Okay.
lord, let me just read one line there. In excess of the powers conferred by the subsection 1 of section 93 Finance Act, such and such, in our act, and in suppression of the notification under,
Not suppression,
sorry,
supersession.
in my lord, I'm sorry, supersession in note of notification number 12/2012, service tax dated 17 March 2012, published in the Gazette of India, extraordinary part 2, such and such. The central government being satisfied that it is necessary in the public interest, so to do, hereby exempt following taxable services from the whole of service tax leviable thereon under section 66B of the said act, and thereafter, my lord, seriatim services are mentioned.
Okay.
Now I fall under point number 13 at page
Page?
number 30, my lord. Services by way of providing of construction of road, erection, commissioning, installation and completion, fitting out, repairs, maintenance, renovation and alteration. I'll pause here for a moment, my lord, and it is an admitted position and also accepted by them that I fall under this category. It is a prima facie case also found by the commissioner, my lord, the authority here. And for that reason, my lord, I have
If you are found to be falling within serial
yes.
number 13,
Yes, my lord.
then why is this demand?
Yes, my lord, I'll satisfy. So prima facie, he says that you have, from the documents which you have given, you have page number, my lord. On that case, I'll directly take the, my lord, to page number 74, my lord. Sorry, 78. Straight away, I will show the finding which he has said. Page number 78, my lord. At the second last paragraph, starting with the word perusal. Page number 78, my lord.
Just a minute, please.
I'm sorry.
78.
8, my lord.
This is what?
This is the finding, my lord, which he is arriving. I'm just showing.
Starts at.
It starts at, my lord. I'm sorry. It starts at discussion.
Order starts at page
61, my lord.
61.
Order starts at page
Long
number
order.
The finding, my lord, is
60. This is 23/2023. This is the impugned order.
Yes, my lord, the impugned order. So impugned order, my lord.
This is passed by whom?
By the.
This is order in original.
Yes, my lord, by the principal commissioner, Dibrugarh.
Yes.
Yes, my lord. Page number 78, as I was showing, the prima facie finding is there, my lord.
Yes, which one?
In the second last paragraph, my lord.
On
starting
perusal.
With the word perusal. On perusal.
Okay, what do you?
On perusal of work orders, contract documents submitted by the noticee and discussed herein, it appears that the noticee has engaged in providing services relating to the construction, repair, alteration, maintenance, renovation of public roads. So that itself qualifies me for under section 13, my lord. Point then, where I failed, probably in the eyes of the authorities, that noticee could not provide completion certificate, running bills, invoices, payments, vouchers, and other relevant documents, records to correlate the contract receipts from the corresponding work orders vis-a-vis the contract recorded in the AS26. So my only failure, my lord, which he says, is that corresponding documents were not provided to me. He never asked me for that document also, because if the authority is prima facie satisfied that I fall under that exemption, he ought to have asked me, my lord. This is the same finding is there also in page number 84, my lord. Now, this is with regard to two investigation authority, my lord. Just two investigation period. So, with regard to the first period, this is the finding. With the second period, my lord, we'll find at page number 84. And same here, my lord, the second last paragraph. On perusal.
78 was for which year, which period?
78 was for, my lord, 1/10/2016 till 31/3/2017, my lord.
3110.
31/3, my lord, I'm sorry. 31/3/2017, my lord. And the second period is page 84.
On perusal.
On perusal, my lord, second last paragraph. On perusal of the work orders, contract documents submitted by the noticee and discussed herein, it appears, my lord will mark that word. It appears that notices is engaged in providing services relating to the construction, repair, alteration, maintenance, renovation of public roads. Then the but comes. So prima facie satisfaction. Same thing is there. The prima period is, my lord, 1/4/2017 till 30/6/2017, my lord. My lord. So, my lord, I have demonstrated that prima facie satisfaction was there on the part of the authority that I do not.
Okay, we'll come back at 2 o'clock.
My lord. May, please, your lordship. May, my lord.
One period is 1/10/2016 to 31/3/2017.
My lord.
And the other one's 1/4/17 to 36/17, right?
36/2017, my lord.
Yes.
So there are basically two FYs they were looking, FY 2016-17 partially and FY 17-18 also partially.
Financial years 2016-17 and
with regard to investigation period in
15-16 and 16-17.
16-17 and 17-18, my lord.
17-18, okay.
My lord. With regard to FY 16-17, my lord, the period was 1/10/2016 to 31/3/2017.
Understood. And the other one is 15-16.
Other one is 1/4/2017 to 30/6/2017.
Okay.
My lord. Now, my lord, having demonstrated, my lord, they have prima facie satisfied themselves, and then as my submission number 1 is this. Now, my lord, what has happened thereafter, my lord, I have shown the why I have not taken the registration. Therefore, my lord, under section 69 of Service Tax Act, if I am liable to pay service tax, that only on that case I am supposed to take registration, my lord, and that is also been upheld by this honorable court.
Now, where is the finding that because of lack of registration? The finding is that you did not furnish the completion certificate running bills.
My lord.
Registration is not the issue. Is it the issue?
Registration, my lord, is because he has not gone into that issue, my lord.
No, not required.
Yeah, he has, my lord. He has. My lord, on that case, we'll turn to yes, page number 86, para number 11.10.
11.0.
11.0, my lord. I'm sorry. 86, my lord.
Yes.
it is also observed that the notary has not obtained service tax registration. My lord,
Yes.
in the paragraph,
Yes.
provided that the taxable service during FY 16-17 and 17-18, thus the notary has contravened the provision of Chapter 5, Finance Act 1994 and rules made thereunder, render himself liable for the penal action under Section 77(1). He quotes the A and imposes in a penalty of 10,000 for non-registration in page number 87. Next page, my lord. Also, the next. Also, from the available record, it is of next page, my lord. After that italics portion, my lord, I hold that notice is liable to pay 10,000 rupees penalty.
Yes.
Under Section 77(1)(a) of Finance Act for non-obtaining service tax registration, my lord.
Okay. That is
Thereafter, my lord, also from the available record, it is observed that the notice did not comply with the submissions of prerequisite documents information sought. So that is the next penalty which he imposes. That I will also address, my lord. So for a moment, my lord, I am coming back to page number 7 of my writ petition for a moment, my lord. And I am submitting, my lord, this, that if I am been found prima facie under Section 13 by the assessing authority, then this penalty is also not applicable and I am not mandatorily registrable under Section 69 of the Service Tax Act. And the same has been held by this honorable court in Magnus Construction also, my lord. That, my lord, citation I have given also in page number 7 of my writ petition, para number 3. Now, why I lay stress on this point?
Where is what was the citation?
My lord, that page number 7 of my writ petition, para number 3, citation is Magnus Construction.
Citation?
2008 15 STT 9 Gauhati.
2008?
15 STT 9 Gauhati.
STT means?
Service tax, probably, my lord, reporter or something. STT.
Service tax times.
Maybe, my lord.
STT.
9 GU. Gauhati.
STT 9.
Gauhati.
Page?
Page number 7, my lord, I have mentioned citation and the relevant part.
Okay.
Para number 31.
Just a minute, Mr. Roy. Okay. Page number
7, my lord.
STT 9.
So the court has said in this case, my lord, the burden of registration and payment of service tax.
Megas.
My lord?
Not Magdas, Megas.
I'm sorry, my lord. Megas Construction. Registration and payment of service tax is on the person who provides taxable service to any person. By applying that logic, my lord, I am not under the preview of Section 69. And therefore, I have not obtained registration.
69 of the
Service Tax Act, my lord. Now, my lord, why I am laying stress on this? I'll correlate in 1 minute, my lord. Is this that the provisions which have been invoked in this case is Section 73(1) of Finance Act, my lord. My lord is aware that 73(1) deals with the extended period. And only in case of, my lord, fraud, misrepresentation, and, my lord, willful misstatement, suppression of fact, or contravention of any provisions of the chapter, then only then 73(1), that is the extended provision, is being used. So, presuming, my lord, if I am been found wanting of some document, if he says that he is prima facie satisfied, then he cannot use Section 73(1). But Section 73(1) has been used indiscriminately upon me without giving any reason whether I have committed any fraud or there is willful disobedience, anything, nothing, no fact, nothing, no evidence has been given to me why Section 73(1) has been used against me. I come back to my submission second, my lord. Now, my lord, what has happened? I have done my one that when in the Chabua airport strip, my lord is aware. I have done some work there. It is probably what I have been told that while lending, my lord, flights, there is some kind of an special coating is to be done. That I have done in Chabua. And for that, I had taken registration under GST, not under service tax, my lord. under GST, temporary registration was taken on 1/7/2017. I had a temporary office there. I surrendered my registration on 17/6/2021
You took registration under?
under GST, my lord. I surrendered my GST registration there.
You had
17/6/2021 is very important date, my lord, because it is the date when I closed down my local office there at the Dubligor under that the local office which I was having. I closed down that also, my lord. That, my lord, will find in page in annexure number 3, my lord. That is in page number, my lord, 51, my lord. I have given the registrations which are there. Page number 51, my lord. It is taken from the GST website itself. And with regard
51,
my lord, annexure number 3.
Yes.
At item number 1 is the GST number which I had taken, and that is inactive. So I have surrendered my GST registration also after completion of that Chabua work. Then, my lord, what happens on 22/4/2022, I receive a show cause notice, my lord. That show cause notice, my lord, I'll take this honorable court to page number 53 for a moment. And I'll like to read 2 paragraphs from that, my lord, and then I'll go to the
date?
53, my lord.
Date
12/4/2022, my lord.
22/4.
I'm so sorry, my lord. I'm so sorry.
Is it 22/4?
Yes, my lord. Yes, my lord. I'm sorry. I'm sorry, my lord.
22/4/2022.
22.
This is a show cause notice.
Yes, my lord. It's a show cause notice been issued to me.
Okay.
Now, my lord, para number 1, he writes, whereas it appears that such and such, here and after notice, presently residing at such and such this Chabua office, which got closed, bearing permanent registration number such, provided taxable service under different category of service to their clients and reported to
Resorted
to the willful suppression of material facts to evade payment of service tax to the tune of 5 crore 13,66,354, including cess for the financial year 16-17. In the that is the relevant period. 17-18, the relevant period is mentioned, my lord, and thereby violated the provisions of 66B, 68, 69, 70 of Chapter 5 of Finance Act, read with Rule 4, 6, 7 of the Service Tax Rules 1994. Now, important is this, my lord, where he says the intelligence has received from the central CBDT that the noticee has provided taxable services to various organizations and collected service tax, but has not paid to the government exchequer. The superintendent of anti-evasion central government central goods and service taxes Dibrugarh requested the noticee video office letter dated such and such, dated is relevant manner 1/11/2021 to submit the following documents. Now on 1/11/2021, when this notice was issued to my Chabua office, my lord, that was already closed by that time. My office got closed on 17/6/2021. And he requests 4 documents there, my lord. Copies of agreement and work order. My lord, may I?
But how did you get this letter?
I did not get this letter. That
No,
I
this
explained.
page 53 letter.
My lord, page.
Page
Yeah,
50
show cause notice has been met. That also I have explained, my lord. On the date of hearing, one of my old employee had given me that letter that this has come.
Date of hearing means?
My lord, on that, yes, my lord, I'll address that issue also. So we were given 2 opportunities of hearing, to my understanding, my lord, subject to the corrections. On 24/2022, my lord, I'll correct, I'll check the facts again.
No,
was
since Mr. Day, since you are trying to make out a case that your Chabua office or the Dibrugarh office was the closed down latest, not late, closed down at 17/6/2021. Latest.
Yes, my lord.
It cannot, because on that day you did not have a valid GST, it became inactive, it surrendered. So this, you say thereafter, that this letter of 1/11/21 requiring you to submit certain documents was tried to be served in your Dibrugarh address by the time which you already left.
Hmm.
So the question from the court is that this particular show cause is also addressed to your Dibrugarh
Yes, my lord.
office.
I'll add.
This 22/4/2022. How did you get this?
Yes, my lord. So what has happened on the, we received an email from their side that this such and such hearing is there.
Who received email
uh,
from whom?
My lord, the assessing authority, the authority under EA, they had sent an email also, but not the show cause notice. That point is also there, my lord. I'll just come to that point in a
One
moment.
email was given to you.
Yes, my lord, that the hearing is there. And because also of this fact, my lord, is this, that we were into rented accommodation. That is my instructions, my lord. And probably, my lord, somebody would have got that copy and they have got a hold of my old employee. Old employee had given that copy to me. And on the first date of hearing, I sought time on this ground that I did not have that SCN also. Please give me some time to reply. And thereafter I replied also, my lord. These facts are on the record, my lord. I'll take this honorable court.
Have you pleaded those?
My lord?
Have you pleaded those facts?
My lord, I've said that thing, that my office got closed and this is how we have got it. Everything has been stated and it has been recorded in the order
Mr.
also.
Kyle, it has been stated. Stated.
I didn't get it. That is, my landlord can contact.
Where is
Page
it?
number 68, my lord.
68.
58, my lord, I'm sorry.
No, in your pleadings.
In my pleadings, my lord, it's part of my reply, my lord. In the reply.
No, reply is a different document.
My lord. Okay,
In the,
my lord.
in the
I'll
pleadings.
I have just briefly covered the points of my reply, but in the reply I have to my proposed notice, I have stated this fact very clearly, my lord.
Okay.
If required, I'll take this honorable court immediately to that part, my lord.
No,
Page-
sir. Why we are asking you this question? Because
lord.
this has got immense relevance from the point of view that because you are arguing the jurisdictional issue.
My lord.
So these will ultimately have an impact on that aspect that you did not have anything.
My lord.
And if at all something has to be done, it would be from the jurisdictional office at Jalandhar.
Jalandhar, my lord. Precisely.
So here, since you claim that you surrendered your registration
My lord.
GST on 17/6/2021 and thereafter
My lord.
you did not have any business at Chabua,
My lord.
Dibrugarh.
No, my lord.
And so neither this document communication requiring you to submit certain documents nor the show cause 22/4/2022 which were dispatched. At that time, you did not have any office.
My lord. This fact is also recorded in the order also, my lord. He has noted down my submissions in the order. This fact has been recorded in the order also, my lord.
What is the finding?
My lord, that is where the finding is in page number, my lord. I will 84, my lord. I wanted, my lord, I wanted this, my lord, I'll show this finding what is there.
84 you have shown?
Yes, my lord. In the 80, I thought I'll show this finding little later, my lord. Now, my lord, will come to the notice in the reply. In the
no, 84 which part?
84 in the second paragraph, my lord.
Yes, notice in the written reply.
The reply to the show cause notice stated that their registered office of the company is at village Bahadurpur, GT Road, Batala, Punjab, and had opened a temporary office Chabua. And the said office has already been closed long since. The address of the noticee has also been verified with the copy of ITR filed for the assessment year 1718 and 18. It has to be 1819. It is written 1818. And it is observed that the name of the village has been mentioned in the return as Bahadurpur. So the fact that my office was at Bahadurpur was, he also satisfies himself.
No, what is the finding after all?
My lord, that is
no finding. No
precisely,
finding.
my lord. Yes, my lord. No finding thereafter. So, if my lord allows, I'll complete that point, my lord. So, my lord, he says thereafter, my lord, that therefore the registered office of the noticee with the village Bahadurpur shall be used for future correspondences. And in page number, my lord, 89, He records that address also.
Both two addresses.
Two addresses, but Bahadurpur address is also recorded there, my lord.
Hmm.
But because of the explicit finding in the unnumbered para number 2, my lord, he is satisfied that my registered office at Bahadurpur EA. Now, my lord, what I was trying to lay emphasis upon is this, my lord, of my point of section 73(1).
Can we have the book? Which one? 73 of?
73(1) of Finance Act, my lord.
Send me that.
If my lord permits, then I will first complete the jurisdictional issue first and then come to 73(1).
Yes.
Because that, my lord, will probably close that gap, my lord. Now, my lord has seen that my registration I have submitted and show cause notice was issued to me. 73(1) I'll touch it at the last, my lord. Now, what is my submission? What I have submitted before that, my lord will find it page number 58, my reply. It is on the date of hearing, my reply, my lord. Anjan Bansal, as representative, has given that reply.
Anjan Bansal is your CA.
Is my CA, my lord, who has given the reply. May I please, ma'am?
Yes.
Sir, this
Yes.
is in reference to the demand show cause notice number such and such dated 12/4/2022, requiring the company to explain
It is
why
not
the
12/4, it should be 22/4 perhaps.
My lord, correct. Company has not paid the service tax on the taxable service to the tune of 5 crore 13 lakhs, such and such,
Right.
for the period between such and such. As today, it is the date of personal hearing on Google Meet, we hereby appoint such and such for personal hearing. First, we like to state that the registered office of the company is at the village Bahadurpur GT Road, Batala, 14th pin number such and such. Hence, the jurisdiction falls under the Commissioner of GST, Jalandhar, Punjab. However, the company has done some contract for which it took GST number of Assam state and opened a temporary office at Chabua. But the work has been already completed. Therefore, the office has already been closed since long. However, we received your notice on that address, which was forwarded by some of our past employee, and Sri Puneet Chopra asked to give us, Puneet Chopra is the, my lord, is the director of the company, asked to give us more time to reply and has not informed the company head office in this regard. But later on 10/2/2023, on the date of hearing, he forwarded the notice to the company, and Sri Ramesh Chopra, director of the company,
Okay,
has asked.
we have read this. Then next, come to the substantial part. In this,
the company is working as a government road contractor and is engaged in exclusively in construction, repair, alteration, maintenance, renovation of roads. Therefore, the income of the company contains mainly from the public road construction. Point 2. As stated above, the company is exclusively engaged in the construction, commission of and completion of repair, maintenance of public road. Therefore, services are exempted. Service VD Mega notification number 26/2012, para 13, he quotes. Next page. Para 59. No other work has been done or executed except repair and maintenance of construction of public roads. 4. Form 26A is downloaded from the income tax website for both the years are also enclosed. From AS 26, we can notice that all the receipts are from government agencies for construction of various public roads. Some of the allotment letters, works related to the different agencies are being enclosed for your perusal. All the works related to repair, strengthening, maintenance, or construction of roads. Therefore, the firm is not liable to obtain registration under Service Tax Act, as all the services provided by the firms are exempted services as per para 13 of the mega exemption. As the company has already closed the office for since long and no employee was there to look after any of the proceedings of the company, therefore it is requested that please transfer our case to jurisdictional commissionerate if your honor needs any further explanation and needs to adjudicate the proceeding, keeping in view such and such. My lord, here I will like to just show one part, my lord, which in my mind, apart from the jurisdictional issue, is important. Is at point number 5, where he says that Form 26, we can notice all the receipts from the government agencies, constructions of various public roads. Some of the allotment letters of the work allotted by the different agencies are being enclosed. Now, what are the documents, my lord, which were been given to the jurisdictional commission, to the assessing authority? That becomes important. That, my lord, is actually answered in, my lord, in my lord, page number 60, my lord. I'll tell the
60.
My lord, I'm telling you that is been exclusively highlighted, my lord. This question. Yes, 68, my lord. I'm sorry.
8.
Now, after the show cause notice hearing is completed, my lord, in the hearing, I'm just briefly summarizing that we said the same thing. We said that all works are from the EA. I will take the required, I'll take the EA. But 68 for a moment, what are the documents which we have given? And there, my lord, is our case is on different footing from the other cases, which my learned senior was trying to rely upon. First, he says copies of income tax return for the financial year 16-17 and 17-18. Copies of balance sheet. My lord would remember in the show cause notice, my lord, in the first letter, balance sheets in 26 AS was there and the work orders were there. We have given that document, my lord. Copies of income tax return, financial such and such, balance sheets of the financial year such and such. Copy of statement of total receipts of the company from 1/10/2026 to the entire investigation period. This copy was given in the email format. He says you have not signed it. So, but he relies upon it also. He relies upon it, but he says that you have not signed it. Be that as may, my lord. Then the copy of order. All the orders, my lord, will see are mostly, my lord, are from the public departments. Let me just read 1-2. Work order such and such dated 26/2016 for PL BM such and such and interlocking tile set Jamuna Wali Road, Police Line Road, Panna Lal Mahajan Marg, Tagore Colony, tender for such and such. There, after he goes on, my lord, work order, all are work order. And apart from the work order, acceptance letter, acceptance of the contract was also given. And he entirely lists out, including the contract documents which have been given up till point number Q on page number 69, my lord. And thus, relying upon this document, he starts the discussion and finding. That, my lord, will start from page number 70, where he says that the crux of the allegation of the present demand notice, karke he starts that. I'll come to this, my lord. Now, my lord, my issue was jurisdiction was with regard to Rule 3 of a service tax of 1994. That Rule 3, my lord, I have quoted also in the reply and my lord, sorry, in my pleadings is also there. My lord will see in for the convenience I have quoted that part, my lord. 1 minute.
You are of section 4 of which act?
My lord, it is 1994, Rule 3, at page number 14, my lord, of my writ petition. I have quoted that rule also. Now, before coming to this on the part of merit, my lord, page number 14 for a moment, my lord, in para number 9, I have quoted the service rule, the relevant rule which gives the jurisdiction to the particular commissionerate. Rule 3 of service tax of 1994. Rule 3, appointment of officers. The Central Board of Excise and Customs may appoint such excise officers as it thinks fit for the exercising powers under Chapter 5 of the Act within such located limits as it may assign to them. Also specify the taxable services in relation to which any such central excise officers shall exercise his powers. Now, this talks about the local jurisdictions, and only under local jurisdiction he can. That local jurisdiction has been defined and elaborated at page number 90. That is the notification number page number 90 for a moment.
90.
90. That is my annexure 8. Now, in page number 90, my lord, it is the notification, my lord. It says notification number 22/2002 C such and such NT in exercise of the powers conferred by sub rule 2 of rule 3, same rule which I have read, my lord. Central such and such, the Central Board of Excise Customs hereby makes the following amendments to the notification of such and such. And this is the notification where, my lord, will turn to page number 92 for a moment first. So on the left hand first column is the Chief Commissionerate's office. That, my lord, at page number 92 will find at Shillong. Chief Commissioner of Excise, Central Excise. Under him, 2 offices comes. First is Dibrugarh, second is Shillong. Now, under Dibrugarh, my lord, what are the places which are covered under Dibrugarh? That, my lord, will find it page number 96. Under entry number 29. (96) for a moment, my lord. Entry number 29. So, with regard to Dibrugarh Commissionerate, what is the jurisdiction which he can access? Or what is his jurisdiction, my lord? That is, he has jurisdiction over state of Arunachal. My lord has got that. Arunachal Pradesh, district of Tinsukia, Dibrugarh, Shivsagar, Jorhat, Darang, Sonitpur, North Lakhimpur, and Dhemaji of state of Assam. With regard to Shillong part also, Shillong has, because the other jurisdiction of state of Assam, my lord, the Kachar and Karimganj are with the Shillong office, my lord. Now, my lord, this explicitly bars him to take up any cases which are outside this venue, local limit. Now, with
Why 29? What is the problem?
29, my lord.
In the state of Arunachal Pradesh, districts of Tinsukia, Dibrugarh.
Yes, my lord. So I am located in Betala, Punjab, my lord. I am located in Betala, Punjab, my lord. He doesn't have jurisdiction over to assess my tax returns, or rather send show cause notices, because his jurisdictions are this. And, my lord, to satisfy my lord's, my lord.
What is the purpose of this notification at page,
my lord,
90?
Page 90, my lord, it gives that under this purpose has actually been explained, my lord, by
So, no, see, this is an amendment of the notification.
my lord.
Which page 90.
My lord.
This is an amendment of the notification which was brought on 8/3/2002.
My lord.
The original notification has been amended.
Yes, my lord.
Okay. Where is the original notification?
My lord, it is presently not there with me, my lord.
No, see, this is an amendment of the notification of 8/3/2002.
My lord.
This amendment notification is dated 4/6.
4/6.
So it's only the certain substitutions have been made in the table, in a tabular form. What was the content of the original notification? Jurisdictional issue. How was jurisdiction conferred?
That, my lord, if my lord will give, I'll get it. But, my lord, let me address this, my lord, because my investigation period is after 4/6/2002.
In that context, we are asking you, the jurisdictional issue would be on the aspect where you worked or where your registered office is located.
That has been answered by CSTAT, my lord. I have that judgment also. That issue has been answered by CSTAT also.
No, I'm not interfering. Section 66C will clarify the entire.
C of the
Finance Act 1990.
that is not before us.
What's it name?
If
Which book? We have that book.
66C.
We'll have that.
Not if everything be clarified, probably other argument for my lot will not be required. If not see goes through this section. This will be clarified everything.
Finance Act.
So for the timing, my book may be taken.
No, that is going to Finance Act. Also the Finance Act, right?
May not be available.
No, we have. এখানে কি আছে এই যে? ব্যারেকটা ঠিক আছে।
66 finance
এখানে তো নাই, এখানে ফাইন্যান্স অ্যাক্ট নাই তো। This book does not have the finance act, I think, goods and services tax. No, this is not. No, এখন দিয়েছেন কিবা দিছিলি তো? You have an extra copy?
Today I have not, but in my, I can provide lots of make it.
আসলে না না।
I would also like to see mail out 166.
66C, the central government determination of place of provisions of service. Central government may, having regard to the nature and description of various services, by rules made in this regard, determine the place where such services are provided or deemed to have provided or agreed to have provided or to have been agreed to be provided. Any rule made in this shall not be invalid merely on the ground of. What do you want to contend, Mr. Skal?
Because Lordship, the service was provided in the Devur district. They may have their office, registered office in other place, but that will not depart the jurisdiction of the authority.
May, having regard to nature of decision by rules made to determine the place. But by rules made in this regard, have you made the rules?
Lordship, at present I am not having, but section is very clear.
No. By this section empowers you to frame a rule that the place of working can be also the place of jurisdiction. But there you need to frame some rules.
That is the Lordship, I have to make inquiry. But Lordship, from the.
Probably it is there, but without the rules being placed before us, to proceed on the assumption that rules are there may not be proper.
Lordship, notice was issued to the place where it was, they executed their work.
No, that is exactly this queries from the court that you are relying on 66C, which gives you the power to proceed even at the place where the work was done. Now for that you need to frame some rules. This act gives you the power to frame rules.
I'll check up and I'll come.
If my lord allows me to, my lord.
Yes, no, you are proceeding, but he says, but if 66C and there are certain rules, then
I appreciate, my lord, what is coming from my lord. But my lord, I was suggesting, my lord, the CSTAT has actually dealt with this issue, my lord, and that is binding upon them. CSTAT has dealt with this issue. Where has to be the office? It has to be the
CSTAT in this proceeding.
Yes, not in this proceeding, but in other proceeding, my lord. And I have mentioned in
a finding of a CSTAT in other proceeding, even if it's unchallenged.
My lord.
No, if it's but we have to go by the rules. If the Act and the rules, Act already gives them a power to frame a rule to confer jurisdiction.
My lord.
It is not in dispute that the work was done in their. You have closed it down. You had a temporary registration because of another work. Okay, but if the work was done in the jurisdictional area of that of this particular commissionerate, then 66D says something else.
For that, my lord, they also have to satisfy. Can they invoke the extended provision? Because what they have done.
No, that we have not even addressed. That will address. That is your first submission.
Yes, my lord.
That will take care. Will
my lord, will give me also time. I will also, my lord, like to look this.
Because 73(1),
my lord,
which you have said that it is only for exceptional circumstances. But they have used the expression suppression.
Whether suppression was there on that,
those are matters of fact.
I'll satisfy, my lord.
Those are matters of fact. We have just cursory had a glance that it is not the aspect of suppression or abuse or whatever is not completely. They have not. They are still having it inside intact, and in fact, that is one of the expressions used by suppression.
Hello.
But still, then 73(1) may not come into operation if you make out a case.
My lord, will give me some.
We heard the matter. We wanted to finish it off. When?
My lord, if it is not.
This Thursday.
No, next Thursday.
Next Thursday. You have to say next.
My lord, can it be after, my lord, 31st March? My lord, I have come.
We'll forget everything after 31st March.
My lord, please, then any day.
New financial year would come. So everything will be erased automatically.
If that lordship this honorable court, Supreme Court is already clearly stated that if they want exemption, then it is their duty to satisfy that department. Not
That is a subtle law. All exemption notice or
Yes.
provision have to be interpreted very strictly
Yes.
because it's an exception. That in spite of there be a provision for payment, they are getting certain exemptions. So you make out a case absolutely on your own.
Yes, sir. That is my lordship. What is the problem if they I'll appeal before the authority?
No, but Mr. Kyle, having said that, see, this is an exempted provision that you are not disputing. The nature of the work.
Finding is there. Why we have invoked this section 37?
But there is also a finding that prima facie, it appears that they followed in the exempted clause.
But whether they have submitted documents as required by the.
What about these documents at page
Yes,
68?
they will not sufficient. Lordship, they have to submit a completion certificate, bills and other all these things. All finding is there, Lordship. And this was decided on this point, Lordship, our High Court has already decided this point.
That case, I will demonstrate, my lord, that doesn't cover my case. However, the case which I am relying upon covers my case of any logistics, where, my lord, but if my lord is fixing on some other day, I will not open up that argument right now.
Service tax.
Service tax, madam,
Service
sir.
tax.
This book is not available in total. Now it will be stored.
তখন রেডি দিবা পেনাল লেভেল
1994, no, sir.
on a lighter vein, we hope that you have not printed it yourself.
No.
Only one copy is there.
This act has been repealed by the STF.
Therefore,
It is what?
it's all it substantiates the hypothesis of the court. It found that it was printed by yourself, so it has been repealed.
I have an extra copy with, and this is appealed by Honorable our High Court. That this act is operation till by section.
Why is it not available?
This is very rarely used. Well, next time I'll come.
I think it's available on net. We can get a print
Yes,
from the net.
Only net also.
Okay. Which is the rules which we require here in this 94 rules? 94 rules.
94 rules will be required, my lord.
You can get those pages photocopied. Okay.
Extra copy. Also.
Not I can, but you can get those pages photocopied.
I have an extra copy of my channel.
Okay.
On 24th, my lord, if it is not inconvenient, my lord.
Okay. Heard pre-ABD Learned Counsel for the petitioner. Also heard Sri SC Kyle Learned Senior Standing Counsel CGST. Para. On a joint request made by the Learned Counsel for the parties, let this matter be listed for admission hearing on
24th, my lord, if it's not inconvenient.
24
March,
March.
my lord.
Is it okay? 24 months? Long time. Why?
My lord, I'll be quick.
On 24th of March 2020.
My lord, will keep it part hard, my lord.
We're not indicating, but if this bench should be there, if it's there, we'll definitely pick it up. Okay. Otherwise.
Deeply obliged, my lord.
Madam, you're actually M. Das. M. Das on behalf of SC Committee CDC.
Approved. Thank you.
Item 9.
এখন থৈ দিয়ে যদি আহে নাহিব পাৰিম তাত এতিয়া নাথাকিব পাৰিম কিন্তু Yes, Forest Department. Mr. D. Gogoi.
He's there, madam. He's just, I'm sending some person.
Madam Monto. D. Gogoi. पानी भी गलत है Madam, not SR Gogoi, D Gogoi. Not SR Gogoi. You only know SR Gogoi. Mr. Gogoi? Gone through.
Accommodation is quite.
Yes, sir.
Because there is an element, my lord, that the petitioner is maybe transgressing beyond his boundary. Beyond his demarcated.
No,
boundary.
that part will make it clear. Whichever the area which is covered by the suit and got confirmed in the appeal, you cannot touch that area.
Is in the interim order first granted by the Justice
As far as that-
Surana, it is also clear,
that-
madam.
Instead of putting this pending, that both parties will maintain their own boundaries and
What is the nature of the interim order, Mr. Decker?
Madam. Huh?
The interim order covers everything.
yes,
The order shall not come into the way of the respondent to presume possession of any other land not covered by the decree.
Yes.
We'll make it absolute. Okay. Third, P.S. Decker, Learned Senior Counsel, assisted by B. Lohkar, by Ms. B. Lohkar, Learned Counsel for the petitioners. Also heard Sri D. Gogoi, Learned Standing Counsel, Forest Department, Para. Considering the facts and circumstances and also consider facts, circumstances of this case which is pending since the year 2023 and also as agreed to by the learned counsel for the parties, comma, the same is taken up for disposal at the admission stage. Full stop. Para. The repetition has been filed with the following prayer, page 12, prayer to court corridor. Para. As per the facts projected, the petition number 1 is the absolute owner in possession of a plot of land measuring 10 bigha covered by Dock number 251, KP Patta number 74 of Revenue Village, Majpara, Mouza, Pholagaon in the district of Kamrup. Full stop. The aforesaid land was purchased by a registered sale deed in the year 1982. Full stop. However, in the year 2006, Mr. Decker, please have your seat. In the year 2006, the Forest Department had made attempts to take possession of a portion of the land. Full stop. The petitioners were accordingly required to institute a title suit being TS number 113 of 2006 before the learned court of civil judge number 3 Kamrup, which was contested by the Forest Department as defendants. Full stop. The suit resulted in a judgment dated 9/4/2012, whereby it was decreed in the favor of the petitioners by declaring right, title, and interest over the suit land and had also confirmed the position. Full stop. The learned trial court had also granted injunction against the Forest Department. Full stop. The aforesaid judgment was the subject matter of an appeal, being title appeal number 10 of 2012, preferred before the additional district judge number 1 Kamrup. Full stop. However, the said appeal was also dismissed by judgment dated 23/11/2015, and the judgment and decree of the learned trial court was affirmed. Full stop. Since then, the petitioners claim to be enjoying the possession of the land in question without any disturbance. Full stop. However, the reason of approaching this court by the present petition is certain activities of the Forest Department undertaken in the last part of April 2023, whereby there was trespass and attempt to dispossess the petitioner from his patta land. Petition number 1 from his patta land. Full stop. It is also alleged that certain trees were cut down. Full stop. Para 3. DECA, the Learned Senior Council, has submitted that the dispute, if any, with regard to the ownership and possession of the land in question has been settled by the judgment dated 9/4/2012, passed by the Learned Trial Court, which has been affirmed by the Learned First Appellate Court by judgment dated 23/11/2015. Full stop. He submits that there being no further appeal by the department against the same, the aforesaid judgment has attained finality. And in that view of the matter, the impugned action on the part of the Forest Department is absolutely illegal, and accordingly, the writ petition is liable to be allowed. Full stop. He has also drawn the attention of this court to the order dated 21/6/2023, passed by this court while issuing notice that to the interim order dated, upward interim order passed by this while issuing notice directing that the respondents would be restrained from taking possession over possession of the land of the petitioner, which is covered by the judgment and decree mentioned above. Full stop. Para 3. D. Gogoi, the Learned Standing Council Forest Department, has submitted that though affidavit in opposition has not been filed, the present activities are not over the land covered by the judgment and decree of the Learned Trial Court, but on adjacent plots of land which are forest land. Correct? Full stop. Para. It appears that the dispute is factual in nature. Full stop. While the petitioners contend that land which were the subject matter of the earlier proceeding in the civil court has once again tried to be trespassed, the department contends that the land in question are outside the purview of the land covered by the judgment and decree dated 9/4/2012. Is it 9/4? Nine 4/2012. Full stop. Para. As mentioned above, this court, while issuing notice via the order dated 21/6/2023, had also passed an interim order. Full stop. This court had also clarified that the same interim order would not come into the way of the respondent authorities to resume possession of lands not covered by the decree. Full stop. For ready reference, the operative portion of the order of the aforesaid order are extracted herein below. Para 6 and 7, order dated, order dated 21/6/2023, 6 and 7. Full stop. Para. This court is of the opinion that in view of the fact that the order dated 9/4/2012 passed by the Learned Trial Court, which has been affirmed, wide the judgment and order dated 23/11/2015 passed by the appellate court has attained finality, and therefore the land which is covered by the aforesaid judgment and decree cannot be the matters of trespassing or taking over possession by the forest authorities. Full stop. However, the forest authorities would not be. However, there cannot be any bar for the forest authorities to take any action for resuming possession of areas outside the decretal land. Full stop. Para. In view of the above, this writ petition stands disposed of by making the interim order absolute.
Item 13.
Item number 13. B. Talukdar G. Gogoi. None appears for the petitioner on call, whereas the state is represented by Sri H. Sharma, the learned additional senior law advocate. Full stop. On the last dates as namely 16/2/2024, 22/4/2024, and 22/4/2024, there was no representation on behalf of the petitioner. Full stop. On the last occasion, that is 13/10/2025, the matter was adjourned by a week to allow the petitioner to have new engaged counsel on record. Full stop. Para. More than sufficient time has elapsed since the last order, and no steps have been taken for engaging new counsel. Full stop. It clearly appears that the petitioner has lost interest in pursuing this case. Full stop. The same is accordingly dismissed on this for want of prosecution. Yes, next.
16.
May I please, Your Lordship?
Yes, it won't go. Yes.
Yes, Your Lordship.
Item number
16, Your Lordship.
yes.
In this case, Your Lordship, matter pertaining to ex gratia, Your Lordship. Your Lordship, the
Same
case.
judgment.
No, Lordship, their vehicle is not identified, Your Lordship. We have filed an additional affidavit by annexing the final report.
So it will be covered by hit and run.
Yes, Lordship. Lordship.
What is the order passed by Honorable Justice Surana for hit and run?
Nisha Khatun's case, Lordship, there the vehicles was
Identified.
In that case, he has to approve the MSCT code, but
No,
here.
even there is a scheme for hit and run, he gets an amount.
As per the notification dated 31/10/2023, Your Lordship, as well as the order of coordinate bench, our case is covered as a hit and run case, Your Lordship.
What is the decision on hit and run? Do you have?
Yes, Lordship.
Mr. Sharma, please examine hit and run.
That Lordship, in that that Monisha Khatun's case, that your Lordship knows that there it is identified. See. If the vehicle is identified, in that case, he has to approach the appropriate court of law. In case of that vehicle is not identified, in that case, he is entitled for this ex gratia, that 2014 notification. Yes, my learned friend has already annexed in the writ petition that.
No, the Act also has a scheme for hit and run. Where is the MSCC?
By this notification, if ex gratia to the NOK of persons killed due to accident in public places or in public areas other than killed by extremists, terrorists, miscreants, and due to the firing of security forces, rupees 2 lakhs.
If we remember correctly, there is also a scheme for hit and run.
But as per
This person was proceeding on foot also.
That is the concept of hit and run. You are not required to be passenger or riding, boarding in the vehicle. No? What is that? Two. You see, Mr. In fact, before the amendment, the original act had a schedule. After the we were looking into the act. In the rules, there is the scheme.
That scheme spent under section 160.
161. You see 161?
Yes.
Even the amount has been specified in 161. No, not there. In the act.
Act itself.
Act. That is the scheme. Act is not there, perhaps. You have to take the act. The Motor Vehicles Act in 1988. Extra copy of the Deals Actor. Well, we are reading out to you. Special provisions as to compensation in case of hit and run, motor accident. Notwithstanding anything, the central government can make the scheme which is with you. Subject to the provision of this act, the scheme made under subsection 3, there shall be paid as compensation in respect of deaths of person resulting from hit and run motor accidents fixed sum of rupees 2 lakh or such higher amount as may be prescribed by the central government. So 2 lakh is the
Yes, sir.
amount.
On the basis of that, most probably this notification is.
That's no, that the scheme is there. This is a different. Ex gratia was meant for entirely different objective. It's not for motor accident. That basic difference is there. It was mainly for bomb blast involving a motor vehicle. For accident, entire thing has been covered by the Act, rules in the scheme. Do you have a copy of the Act? Mr. Sharma, if you read this Act, it will listen.
Yes.
So he is a statutory right. There cannot be overlapping. What is the ex gratia amount, Mr.?
2 lakhs.
2 lakhs. Then
Yes.
you cannot get both.
No.
What about, did you apply under the MSP?
No, Lordship.
Have you made a statement?
No, Lordship, because vehicle was not identified.
No, that is what. You can still apply under the scheme.
No, Lordship.
Now you make a statement on oath, on affidavit, will not dismiss your petition, will allow it. Because if you're entitled to the same amount, but ideally you should go under the rules.
Yes, Lordship. At page 8, your Lordship, paragraph number 8, we have stated regarding the petitioner begs to state that she has not made any claim before the Motor Accident Claims Tribunal for obtaining compensation as because the vehicle involved in the accident is not identified.
That is not the explanation. You had not made the claim thinking that since the vehicle is not identified, you cannot. You can still make a claim. There is a scheme specifically scheme under 161 section.
There is a provision, but that amount may most probably cooperated with state government and central government, and our claim is as per the notification of.
See, you
state
cannot
government.
get two claims.
We are not claiming both.
No. We do not know. There has to be a statement that I'm foregoing that my right to go under that thing.
Lordship, can it reflected in the order? We are not going to the.
See, prima facie, we will not like to enter in this petition. We'll allow you to go to the MS under the scheme. But still, this petition is pending. But it's not a new old petition. We don't want to open a floodgate in the name of ex gratia. Anybody and everything can come.
Lordship, I will file additional.
If you file then in exceptional circumstances, we may say that since the amount is the same,
Yes, sir.
only because of that. Heard Sri S.I. Akand, learned counsel for the petitioner. Also heard Sri H. Sharma, learned additional senior advocate, and Miss P.R. Mohanto, learned standing counsel, Revenue Department. Full stop. Para. The claim in this writ petition is for ex gratia payment for the deaths of the husband of the petitioner in a road traffic accident. Full stop. It is contended that the vehicle could not be identified and the petitioner has relied upon a notification dated 15 November 2014, which has been clarified by a notification dated 31/10/2023 that the 23, full stop. By this clarificatory notification, it has been stated that victims of hit and run case not traveling in vehicle shall be entitled to such ex gratia payment. Full stop. Para. This court has, however, noted that the Motor Vehicles Act, that under section 161 of the Motor Vehicles Act 1988 provides for a situation, or provides for payment of compensation in a situation of hit and run, and the said, and in accordance with the said section, comma, the compensation to victims of hit and run motor vehicle accident scheme 2022 has been framed. Put stop para. This court has also noticed that the amount of compensation, the amount provided is the same, namely rupees 2 lakh. Put stop para. In view of the above, comma, the petitioner is required to file an additional affidavit undertaking that a parallel claim under the Motor Vehicles Act and the scheme shall not be made in the event the present petition is allowed. List after 3 weeks. File it within 2 weeks.
I will file immediately.
You file it, list on. We'll have it on 23rd of March, okay? Can you do it?
Not of March, Lordship. There is the occasion of Eid, so.
26th or 27th,
Lordship.
whichever, 26th.
So blessed.
Eid is on 21st. Why on 23rd? You cannot come.
Same from Kokrasar.
You're from Kukrazar?
Yes, sir.
How many kilometers? 1 lakh? Or 10,000 kilometers?
96.
You come by foot or what? Train.
May I please, your lordship? Lordship, I pray for withdraw my affidavit in reply. There is an error in my reply. That's why I want.
When did you file?
Last week.
You're for which department?
Lordship?
You're for the petitioner?
Yes.
Item number?
70.
What is your name, madam?
H. Thak. H. Thakuria.
Madam Thakur, you cannot, there is no provision for withdrawing affidavit. What provision can you withdraw an affidavit? You have to tell us.
Actually, I
You can file an additional one more affidavit, clarify it.
Okay.
Your lordship, madam. False statement, my lord. Suppose your honorable court by swearing affidavit, madam. Your lordship may kindly see page 50 of affidavit in reply matter. He has stated it may mention here that out of 6 legal heirs, all were expired except present writ petitioner. Legal heir of deceased, namely Sanjeev Kumar Sharma, expired on 5/20. Sanjay Kumar expired on 14th. Rajiv Kumar Sharma expired on 14th. Manjushri Sharma expired on 7/11/2004, and Bonasri Sharma expired, but before her date, she issued no objection certificate in favor of her eldest brother, namely Ranjit Kumar Sharma. Now, he is the elder brother now. He has made affidavit by swearing affidavit, my lord. He has stated. Now they have stated that Bonasri Sharma is alive, my lord. Very false statement. In the petition also, he has stated that he.
Madam, perjury. Criminal proceeding will be initiated against your client.
Lordship, it's.
Now, Siri, we are making a very serious statement. You cannot play with the law like this. We'll direct initiation of a criminal proceeding. Who is the deponent? Who is the deponent?
Kumar Sharma.
Where is he? What is he? Where does he stay?
Lordship,
He'll have to initiate, face a proceeding. Some innocuous statement, he's making a statement of his own relative stating to be dead.
Lordship, my fault.
Petition also he has stated he is the only legal heir.
No, that,
Only legal
that,
care for,
no,
give
that
the
can,
lord-
that can be a misinterpretation. He doesn't understand. But if he says that somebody is dead, then there is no excuse.
But in this case, specifically stated, my lord. And one makes sense.
Madam, you're inviting trouble. Not inviting, you have invited trouble. Where is the affidavit or rejoinder affidavit? Not come to record. When was it filed?
53.
It has not come on record.
Was filed on 6/2/2026, my lord.
It does not come on record. Heard Miss H. Thakuria, learned counsel for the petitioner. Also heard Miss T. Goswami, learned counsel for the AFDC.
Yes, my lord, yes.
No, AFC, Assam Financial Corp, AFC. Full stop. While Miss Thakuria, the learned counsel, has informed that rejoinder affidavit has been filed, she has submitted that there are some error in the affidavit. Full stop para. On the other hand, error and therefore, a clarificatory affidavit is required to be filed. Para. On the other hand, Ms. Goswami, the learned counsel for the AFC, has submitted that false statement has been made in the affidavit, and the said aspect is required to be looked into by this court. Full stop. Let the affidavit, rejoinder affidavit, be brought on record. Para. Since a proceeding under Article 226 of the Constitution of India is a proceeding which is sacrosanct in nature, the aspect of the bona fide on the part of the petitioner, on the part of the party approaching this court, is of paramount importance. Full stop. Therefore, it is made clear that appropriate orders will be passed if it is found that false statements have been made on affidavit which were known to be false by the deponent. Full stop. List on 11th of March.
Nice.
May I please, your lordship?
18 years.
Yes, lordship, here in this case, lordship, affidavit in opposition also filed and rejoinder also filed, lordship, but rejoinder is not come on record, lordship.
You filed rejoinder.
Yes, lordship.
Opposition has come.
Yes.
Mr. Sahal for 5.
Yes.
5, who is 5?
Now,
Private respondent.
Lordship,
Election matter,
Yes.
violation of the children condition, more than two children.
Yes, Lordship.
You have alleged that there are, then what is your,
Anything children, but we are saying that too, I too, that is my brother's son, Khajan. That I have produced a certificate also, birth certificate. You are wrongly named.
you have disowned your child.
My child, virtually my brother's child, because I being the.
Now who will make this factual determination?
Lordship,
We cannot make.
We filed an RTI application, and in RTI reply, Lordship, concerned hospital and other health officers, Lordship, clarify this thing. This third child is the respondent number 5 child, Lordship. And
Do you have the birth certificate?
I have the birth certificate.
Name of the father, mother different.
how it is changed, Lordship, they explain, Lordship, and it's available on rejoinder, Lordship. Let it be come on record, Lordship, on Monday.
Yes, Mr. Das.
Filed by they were not personally agree person.
Who are they? Voters.
Voter of the same TP, Lordship.
Huh?
It is also different.
But you are a voter.
Yes, voter of the same group, Lordship.
You are not a contesting candidate. How will it make a difference? Let a contesting candidate come.
Yes.
But the voters within the same jurisdiction.
Understood. You are not a contesting. If he goes, you are not going to win.
They complained before the deputy commissioner, Lordship.
Who has complained? A voter.
Voter, Lordship.
How much enforceable right have you got to question? Let a contesting candidate come.
Lordship, I think the voter also can complain, Lordship.
You can, but how much enforceable right? What prejudice are you suffering? If no contesting candidate, why should we again go for another election?
Somebody by cheating, Lordship, who owns the
Oh,
election.
the agree party is not before us. Why somebody is behind you? Let him come. Why are you set up? Let the contesting candidate come. He is not aggrieved.
On the same TP, Lordship, in another candidate, Lordship, CEO also initiate the inquiry on the basis of the.
Why the
voters.
contesting candidate is not coming?
They have not filed complaint.
Why?
Still they can, that's open, Lordship.
We're not going to invoke our jurisdiction for matters again explain. Let the appropriate party come, will definitely. Elections are hell now. Prima facie, there is a birth certificate. If prima facie case would have been made out, matter would have been different. Okay, let the rejoinder come. Let the rejoinder come.
Let's
Okay.
rejoinder.
What is your name?
T.A. Chaudhary, Lordship.
TA. Heard Sri T.A. Chaudhary, Learned Counsel for the petitioners. Also heard Sri Endas, Learned State Counsel, Sri S. Datta, Learned Standing Counsel PNRD, Ms. Kastha, Learned Counsel for the State Election Commission, and Sri G.N. Sahala, Learned Senior Counsel for the respondent number 5. Full stop. The respondent number 5 has filed affidavit in opposition, against which Sri Chaudhary, the Learned Counsel, has informed that a rejoinder affidavit has been filed, which however is not tagged with the records. Para, list on office to verify and list this matter along with the rejoinder affidavit on 11/3, third week, on 23rd, 23/3, okay?
April. Can it be on 25th, Lordship?
24th then, 24th, 25th, okay, one more day, 25th.
Item 19 to 20.
Mr. Datta, which is your matter again? This matter, Mr. Das's matter. Okay. This is your matter.
Lordship, my matter item number 19, 21 and 22, Lordship.
Okay.
So, Lordship, matter pertaining the land acquisition, Lordship. So, herein, Lordship, the petitioner land was acquired in the year 2001, Lordship. By the
2001?
Yes, Lordship. By the Water Resource Department, Lordship. Lordship, that since last 2001, Lordship, that not a single penny has been provided by the concerned authority, Lordship.
2001 land acquired.
Yes, Lordship.
Before my narration starts, Lordship.
Just a minute, we want to listen to Mr. Das.
Not received any instructions.
Why are you depriving us from hearing him?
Extremely sorry.
At 3:30, he comes to the court.
Lordship.
Let us also enjoy. Why are you smiling, Mr. Das? We are not referring to you. We want to listen to Mr. R.C. Das, not N. Das. Yes.
So
Land
Lordship,
was acquired in 2001. For
Yes.
what purpose?
in regard Lordship, the flood control of the Ghagra River in the under the Mongoldo jurisdiction, Lordship.
No, for what purpose?
Embankment-
Why was it required? What was the purpose of the acquisition?
So in regard to the flood control of the Ghagra River, both bank of the
For
embankment.
flood control, land
Yes.
acquired.
Yes, Lordship, on that purpose, Lordship.
You can control flood by acquiring land.
So the government is a scheme, Lordship, the scheme of the government.
No, no, no. Wait, let us understand. How do you control flood by acquiring land?
Sorry, embankment, Lordship.
Embankment. Okay. Okay. The land was acquired to construct an embankment.
Yes, Lordship.
Okay. It was done in 2001. How much land?
So my land is, Lordship, 6 biga 4 katha 19 lassa, Lordship. It's a different part of
6 view here.
yes, 6 biga 4 katha and 19 lassa.
19 lectures. Okay.
So here in Lordship, the
Was there any proceeding? Land acquisition proceeding?
yes, Lordship, the land acquisition proceedings, Lordship, the LA
Number? LA number?
6/2001 and 2, Lordship.
LA 6 of 2001, 2002.
2001 and 2, Lordship.
There was an award.
So one similar shared person already received the amount, Lordship.
Award was there.
Yes, Lordship.
Award dated?
Awarded in the year 2023 is the last part, Lordship. So
20, award is of 23.
yes, Lordship.
How come? After 22 years? Let us see the award.
So Lordship, the department initially did not provide the award, Lordship. So that's why, Lordship, the similar shared person who has serial number 34, Lordship, is Asiruddin Ahmed, Lordship. So after long term, Lordship, so they have approached several times, Lordship. The subsequently approached in regard to the writ petition, and the court is appreciate and the award given, Lordship.
Award given. Where is the award? Page?
Lordship, one judgment I have appended, Lordship, page 57, Lordship, can be found. Annex
57.
Yes, Lordship.
Okay.
The writ petition number 494, Lordship. And the relevant part is 61, Lordship.
You are not the counsel.
Yes, Lordship.
You are the counsel.
Yes, Lordship. Lordship, relevant part is page 60.
You are not the counsel. Some RM Das is the counsel. RM Das was the
One
respondent.
of the respondent, Lordship.
Okay, okay.
I was the field, Lordship.
What was the order?
Lordship, relevant part is page 62, Lordship. The order.
62.
Judgment, yes, Lordship. Fine, Lordship. Page 62, Lordship.
Taking into account that they would have been liberty to file appeal before the district.
So, first paragraph, Lordship, may I read, Lordship. This is suspended 18 PM 2000.
Allegation reference to the under so and so and so. It is a case where reference has been directed to be made.
Yes, Lordship.
Have you received any amount?
Yes, Lordship.
How much?
I have received, Lordship, the 86 lakhs 13.
No,
33
this was in
lakhs.
another case, your case. What amount have you received?
So not a single penny, Lordship. In this case, not a single penny, Lordship. So this is a different case. Gazette notification number 34. Asiruddin Ahmed.
So in that case,
Similar person, I have amended that judgment, Lordship.
how is it similar? In that case, there was an award. He had got 86 lakhs. Court says that if you're aggrieved by the adequacy, you can approach for making a reference. That was the order. Where is the award in your case? You show us the award that you have received or not received.
So, Lordship, the respondent authority, Lordship, one part has revised and page 54, Lordship, the ADC of the Dorong, Lordship. Page
54.
Lordship, 54.
54, yes.
54, and relevant part is 55, Lordship.
55, where are you? What is your name?
So here in Lordship, the serial number 3, Lordship. From the left side, Lordship.
Yes.
LA case number 6 of the 2001 and 2, Lordship.
Yes.
So here in Congress, Lordship, the total 79 bigha, 3 bigha, 8 less, Lordship.
You are connected with this 6 of
2001 and 2, Lordship.
How do you, what are the documents where your name is there with 6?
Lordship, in a gazette notification, kindly find, Lordship. Gazette notification page, Lordship, 36, Lordship. My serial number is 27, 28, 62, 63, and 64.
36.
27.
Gazette notification.
Page 36, Lordship, gazette notification.
What is the date of this?
Type copy, Lordship.
What is the date of this gazette notification?
Lordship, 2014, Lordship. The type copy original part is page, I start from 38, Lordship. These are very indistinct copy, Lordship. So here in Lordship, the gazette notification page, serial number 27, 28, 62, 63, 64, and 34, Lordship. 34 is another petition, Lordship.
Yes, what do you say? We wanted to put the question on of delay. Land acquisition case of 2001 and 2. But there is a communication of 2022 where gazette notification. His name appears in that gazette notification, including the area which has been acquired. Now thereafter he says that he has not received anything. Herefore,
Department.
okay.
Actually, my lord, there is a connected case. There are some 70 people in the group in LA case 6 of.
It connects how many? A lot of
Lot many cases.
other than the petitioners. How many total?
In total, Lordship, 127 Partata, Lordship, out of the 80 bigha, Lordship.
How many of you are there? 18 in these cases?
6. 6?
6, total 6 petitioners.
Yes, Lordship.
In these 2 cases or 3 cases?
Yes, Lordship.
Affidavit has been filed by the DC Dharan in another case, which is not before your lordship today. There, my lord, detail have been description.
What is your stand?
They have been given that
Compensation.
No, it is there, my lord, on record, my lord.
So,
Maybe
Lordship,
listed along with the petition number 2555 of 2020.
That is not disposed of. We'll have it with that.
so Lordship, we do respect, Lordship. So my learned friend state, Lordship. So the 86 tax office, Lordship, on the basis of the market value, section 24 subclause 2 of the new fair act. This clear defined.
No, Mr. Das, there are 2 aspects. One is not receiving anything.
Yes.
And number 2, you are aggrieved by the sufficiency of the compensation.
Yes.
If you are aggrieved by the sufficiency, we have the earlier orders. In spite of that, or irrespective of orders there or not, we must still make an observation that if you are at liberty to go for a reference. But if you make out a case that you have not received anything, which madam has said something else that you have received.
In 2008 only he was paid 10 lakhs 5,000.
So, Lordship, that amount received by the serial number 34 Asiruddin, Lordship. So, as per the section 24 subclause 2 is a new fair act is observed, Lordship. So the section 54.
Asiruddin is the owner of another plot of land. He has received.
Yes,
You said that you are owner of a plot of land of 6 bigha, 4 katha, 19 lakhs.
Yes, Lordship.
Now somebody has received, doesn't mean that if the record shows that you have also received, you cannot take the pretext of Asiruddin.
Is a difference, Pattada Lordship. The Asiruddin is different.
No, madam is not on Asiruddin. Madam is that received by you 10 lakhs.
Item number 20, 20 Lordship. So it's not my case, Lordship. They are not my friend.
What about Mr. Arsidas's client? Did he receive anything?
Shaharia, the instruction is, my lord, the land he is saying is not in his name, and it is in the name of some Bipin coach.
Oh. Who is Vipin coach?
That part I have stated, Lordship. He's a father of the.
Who is Vipin coach, Mr. Das?
Bipin coach is a son. Gohin coach is Gohin Soria is the son of the Bipin coach, Lordship. I have stated, Lordship. So paragraph, Lordship, I have given, Lordship, each and every paragraph, Lordship. So the son has claimed, Lordship. The Bipin coach, I'm sure, Lordship, the Bipin coach name is reflecting the gazette notification, but here in, Lordship, so the Gohin.
You are the son.
I am the son, Lordship.
Okay. Madam? If your affidavit filed in the other case covers this issue, then we'll have the when analogous hearing. If you want to rely upon that affidavit, you can. In that case, you have to give him a copy so that he can file a rejoinder.
Yes, Lordship. So I have already served the copy, Lordship.
You have been served a copy.
Already extractly served, Lordship.
Now, are you the counsel in the other case also?
Yes, Lordship.
Madam Chakraborty, he is the counsel in that case.
He's counsel in 3 cases.
Yes, Lordship.
No, no.
Item number.
The objective of have. No, he needs to be served with a copy. If you're relying upon on an affidavit, you need to serve him and he give him a chance to file rejoinder in this affidavit also based on that.
Yes.
Okay.
Yes, Lordship.
Yes, please take it. Heard. You are also there. 20. Madam, in his case, you are relying on the same affidavit.
Same affidavit.
Heard. 3. Ratan Chandra Das, learned counsel for the petitioners in WPC.
WBC 6443
6443 2025 and 6487 2025 6496 2025. 3 petitions. Whereas 3 M. Hussain, learned counsel, appears for the petitioner in WPC 3097 of 2024. M. Hussain का एक petition है. Full stop. The claim is with regard to compensation for land acquisition, which was done. Land acquisition. Full stop. The land acquisition. The land acquisition proceeding was registered as LA case number 6 of 2001-2002 for acquisition of land in the district of Darang by the Water Resource Department. Full stop. The petitioners have relied upon a gazette notification of the year 2022, wherein the names of
Lordship, sorry, 2014 Lordship, yes,
14. 2014. But why have you come to the court so late after 14?
Don't know the department.
Huh?
I don't
Not
know.
department. Why have you? Department has not come to the court. If the gazette was a 14, we have come to the court in 25 after 11 years. Why?
So we approached several times, Lordship.
Where?
Before the concerned authority, Lordship.
11 years you have not explained. We thought it was 2022.
Lordship, submit the representation, Lordship.
Representation will not extend your. What about the lectures on your part? 11 years you take to come to the court.
It's not the layman in this regard, Lordship. Nothing idea in this regard. So 7 times they approached before the concerned authority, Lordship.
Cannot be your advice, Mr. Das. You will not give them advice to wait till 11 years. Did you advise them to wait till 11 years?
No.
No. Land Reliance Apurna, reasonable eviction of 2014. Names of the land affected persons have been stated, which includes the names of the petitioner. Para. Miss P. Chakraborty, Learned Standing Council. Standing Council. The Standing Council Water Resource Department has, however, submitted that there are certain other petitions filed on similar lines. And in WPC 2555 of 2025, an affidavit in opposition has been filed, which would also cover the present writ petitions. Full stop. Para. In the interest of justice, let a copy of the affidavit in opposition filed in that writ petition be served on the learned counsel for the petitioners in these cases. Full stop. Further, liberty is granted to the petitioners to file rejoinder affidavit to such affidavit in opposition. Full stop. List along with WPC to likha tha, yeah? No, we'll write one only, that 25 something. 2555. A list along with so and so on. When? How soon can you file the rejoinder, Mr. Das?
Lordship, 5 member representation, Lordship.
No. How soon can you file the rejoinder?
So, 25th, Lordship. 25th.
Before 25th, can you file?
Yes, Lordship.
Okay. On 25th, 25/3, prior to which date, rejoinder affidavit may be filed.
Yes, Lordship.
Okay. Is there any interim order? No interim order.
No. So, Lordship, I may be wrong, Lordship. So
You are not wrong. You are always right.
So, Honorable Supreme Court held, Lordship, 2 judgment, Lordship. One is the Tukaram Kana Doshi case, another is the HD Bora case. So, there are consist, Lordship, that after 30 years, Lordship, the entitled the land acquisition matter, Lordship. The Supreme Court held, Lordship. So,
After what? 30 years?
30 years, Lordship.
What has been held?
So, entitled the land acquisition compensation, Lordship. The
Entitled
Tukaram
for
Kana
land
Doshi-
acquisition.
Yes, sir. In regard to, Lordship, Article 300A of the Constitution, Lordship, deprive of the property on that way, Lordship.
Next time you place those.
So I have quoted, Lordship, in my big
The
petition.
entire bar are also listening to you. They have to learn a lot from you. Mr. Roy Chaudhary?
So this is a lack of communication, Lordship, something.
Lack of communication of whom?
So wrongly stated, Lordship, something, Lordship.
No.
Yes, absolutely.
Okay, next time you place the decision.
Yes, Lordship.
Tukaram and what?
Yeah, HD Bora case, Lordship.
HD Bora from Assam.
No, Lordship. It's a
Bora is from Assam.
Bora BORA, Lordship. It's a-
Oh, viewer, I think.
it's a
Bora.
Maharashtra, Lordship. Maharashtra. BORA.
He has gone from Morigaon to stay there.
Mudar Maharashtra, Lordship.
Okay.
Master.
We'll resume on 25th. 25th, what is the date? 25th.
Yes.
I can do it for something.
May it please your lordship. My lord, the petitioner is the husband. My lord, he has filed an application for divorce under Talake Hassan. My lord, that can be in writing. So he had filed 3 different dates. One on
Husband has filed the divorce petition.
divorce applications, Talake Hassan.
You filed before whom?
No, I have sent it to my wife because I have to pronounce 3 times.
Okay, you have, okay.
By writing, my lord, I can, under the different modes of talak, there is a talake Hassan, which it can be
What
sent.
is the pronouncement of the Supreme Court on this?
My
Is
lord,
it valid?
I have,
Is it valid?
my lord, there is a judgment. Let me.
Is it a valid way?
My lord, because
Recognized mode still.
my lord, and that has been taken
But
care
something
of.
has been said by the Honorable Supreme Court.
My lord, that has been taken care of by a coordinate bench, and I've annexed the judgment, my lord. 2017, it has taken care of. But only application.
So you have pronounced talaq 3 times.
3 times.
Thereafter?
Thereafter, my lord.
And that too in writing.
In writing, and there are postal my lord, postal registered post, it was taken, whether it was duly received, tracking of the postal receipts also I've annexed. Then I filed an application under section 12, under the act of my lord, the Assam compulsory, my lord, the act is the Assam Compulsory Registration of Muslim Marriage and Divorce Act 2024.
This provides for filing.
Registration, provides for registration of divorce. Talaq, that registration of divorces under the Muslim Act of 2020. This is of 2024. My only grievance, which I filed before
Act of 2012.
2024.
Okay.
My lord, which I filed before the Deputy Commissioner, that he has not acted upon that. Now, whether the divorce has taken care of, or it has been affected or non-affected, this all will be taken care of under section 12. So, my lord, my only grievance is that he is not taking care of my application, which I filed under section 12. So,
who is the registering authority?
The Deputy Commissioner. My lord, I have filed my
registrar.
That.
This is the registrar.
My lord, the Deputy Commissioner. I filed my application, my lord, at page 34. My lord, now the private respondent has raised the point that
the alia for private respondent.
Thank you, wife.
What do you say?
My lord, first, my lord, this writ petition is not maintainable. Because under the divorce, my lord, although I have disputed the divorce and the manner in which, my lord, divorce is, my lord, pronounced, it is again the verdict of the Honorable Supreme Court. And the divorce effected, my lord, when the new act was not in force. Therefore, my lord, this act will not applicable in this case also. And my learned friend has annexed, my lord, one judgment of this on court, my lord, and which was referred, my lord, dissenting view of this Honorable Supreme Court, which was quoted in the order.
Is it?
Lordship.
Which page? Which page?
Yes, T2, my lord. They have annexed one order, my lord, case 41, and relied paragraph 116, my lord. Paragraph 116 of this says judgment or decision dissenting reverse.
But I am not talking about this judgment. The act came in, my lord, October 2024. I have filed my application under section 12 in November 2024. So this act will cover, my lord. Whether it is affected, non-affected, whether judgment was wrong, whatever it is, my lord, that will take care of.
But if that the dissenting thing is not the majority, that is not the law.
But what I am there, I have placed my application. The section itself.
If the application is not preceded by an admitted fact of pronouncing or writing 3 talaqs, then how will the application be?
Section 12(2) says, but on receipt of such application, the marriage and divorce registrar shall satisfy himself whether or not such divorce was affected by the persons or persons by whom the divorce is claimed to have been affected.
Now, if this mode it has been deprecated by the Honorable Supreme Court, then where is the question of there being a valid talaq?
That will be decided by the registrar. Registrar will say it's not affected.
No, on the admitted facts, pronouncing 3 talaqs is been held. Where is the judgment of the Honorable Supreme Court?
Which has been quoted by this court is that your lordship will find
2017 9 SCC 1.
My lord. And that page 43, my lord, this court has also discussed in para 4.
So, but the quotation is a para 116.
My lord.
It's part of the dissenting judgment.
What dissenting judgment?
This is very interesting. We have to. You also examine this aspect.
My lord, I will look.
Because we have not examined.
My lord. The only thing is
broadly, that is the thing. Unless the mode is correct, and this part you are admitting that it is by means of 3 talaqs.
Well, that I admit. I have sent it to registered
So
post.
registration is not a mechanical process. He has to satisfy himself. Now, if this was the mode adopted, which is declared illegal by the Supreme Court, he has good reasons not to register the
Whether
divorce.
this Talake Hassan by registered post has been, well, that I will look into that judgment. Three consecutive dates and differ in a lapse of 1 month each. If that particularly is not in a descending, then my lord, your lordship may keep it parted and fix it on date.
Not parted, will
On Tuesday, my lord, this Tuesday it will be enough. This
Mr. Ali?
Tuesday.
Mr. Das? I think your assistance will also be required. I think you have got the issue involved. There was no bar. No portal was there. No, we are not on the this technical aspect. We are on the aspect whether a divorce can be registered if the divorce was done by following the procedure, this procedure. Now it is not a pronouncement. He has sent by post on, not immediately.
After every month, succeeding month.
So under those conditions, and receipt of those have not been denied by them. Have you denied?
Denied, my lord.
But our postal track says they have delivered and received.
We have denied, and in the notice also, my lord, there is no reason. The Honorable Supreme Court said, my lord, it should be.
No.
Those
Mr. Ali,
things will
let
be
us
taken.
not mix up issues. Requirement of reasons will definitely examine. But first is whether you have received. If you have said you have not received, matter ends there. Now, if you said you have received, but reasons, then we'll come to the reasons part. There will be all different stages of examination. We'll examine whenever it is, whatever is required.
Can I place one thing, Madam? Because after I file an application, they will send a notice to them. They will also appear, both the parties will appear. The registered authority will look into it, whether there is at all a divorce effected or not. Then there will be a proper hearing, then they will decide for registration. It is not mechanically. The writ court is not here to see whether it is there or not. Only my grievance is that my application was that. That can be cancelled also. Then a subsequent action will be taken care of by a writ court again, whether in merit or otherwise.
But can they sit over the matter without
now you're
without coming to a conclusion? You say that can be rejected also.
Rejected also.
After giving reasons. But the registering authority is only sitting over it, not acting on it.
Not acting on it.
That is your grievance.
Because section 12 is this, my lord. Because section 12 says whenever
Mr. Das, for that part, he can pass an speaking order, he can.
No, that. Portal we are not said, we have to register post.
Can it be?
You get the up-to-date instructions.
No, our application was filed by a stamp paper before the authority, not portal. By a written application, we have filed it before the authority. And it was by a stamp, we have filed it before the authority and notarized, and it was filed on 30th day of November 2024. Your lordship may just, one consideration can be taken care of, whether this mode of divorce has been nullified by the Supreme Court.
No, Mr. Roy Chaudhary, since final orders have not been passed by the registering authority, this aspect, at this stage, we may not express any opinion. Let the registering authority either reject or accept.
That
in any case, both of you will have the remedy to challenge it. If it is accepted, Mr. Ali, if you are aggrieved, you can challenge it that the mode was not correct. If he rejects it, you are there. At this stage, should we say anything? Since he has not taken a decision.
Prejudice either of the part. And my lord, the coordinate bench also held that both the parties will be heard.
But that reliance on 116 perhaps may not be a proper procedure. You examine that aspect. That appears to be a part of the descending judgment.
My lord, that I look into, my lord, I will be 17.
2017.
17 judgment. And my lord, that 17 judgment and this.
Do you have a copy of the judgment?
And this act came in 2024. So this judgment will not affect this act. This is the act in 2024.
Pending these stuff.
In view, in view of the different opinions recorded by a majority of 3:2, the practice of talaki bidat, that is triple talak, is set aside.
But and talake Hassan,
We have to
because the modes of talak.
they have to make a distinction between talake bidat and talake Hassan.
My lord, here in the definitions, what I get, my lord,
You are having mullah or what?
Mullah bhai. Modes of pronouncement. A talak may be effected orally by spoken words, by written documents, and there are three forms of talake Hassan, talake ehsan, talake Hassan, talake bidat, and talake badai. So, my lord, talake Hassan, the consists of three pronouncements made during successive 2 hours, no intercourse taking place during any of these 3 2 hours. That is talake Hassan. So, there are 3 modes of.
Now, what about the talake bidat?
Bidat is different. Talake bidat is the consist of 3 pronouncements made during single tour, either in one sentence or a single pronouncement. So this is different, and talake Hassan is different. But this your lordship will look into this.
Okay, next time we'll look into it. Next time, you give a photocopy of that mullah's interpretation.
What I understand from the lordship saying is that has discussed about talake bidat. That is the third mode of.
That is talake bidat.
So
Triple talak. It has been clarified. Triple talak.
In one single pronouncement will not be allowed. That is what talake bidat. In one single marriage, one to her. Here, succeeding is different. Talake, one ehsan, Hassan, bidan. Bidan has been discussed in 2007.
But Mr. Das, he can take a call either this way or that way, but he has to finally dispose of the application. Application was entertained when? When did you file?
My lord, 30th November, I think, my lord.
And did you appear, Mr. Ali? Have you received notice? You have not received notice.
30th November 20.
He has a right to be heard.
Well, definitely.
But notice has not been issued.
No, my lord, because he's kept it pending. That is my grievance. He has to take a cognizance, issue notice. Then mother raised it.
The prayer is to, if you also come to page 11, it's not 10 of annexure 6. When we go to annexure 6, there is the application before the decision.
That is my only prayer.
I can take up to the next.
Yes, take instructions on that. Mr. Ali, you can contest before the registering authority, deputy commissioner. He is the registrar.
No, he is the.
Which district?
Kamrup.
Heard. 3 P.K. Roy Chaudhary, learned counsel for the petitioner. Also heard 3 Endas, learned state counsel, and 3 R. Ali, learned counsel for the respondent number 4, full stop. The pleadings between the contesting parties have been exchanged, full stop para. The grievance being primarily against inaction of the registering authority to act on the application dated
30th non.
30/11/2024, filed under section 12 of the
Assam compulsory registration of Muslim,
Assam Compulsory Registration of Muslim Marriage and Divorces Act 2024, comma, the Learned State Council is directed to obtain instructions. Full stop. No, usse pehle likho. Usse pehle likho. Sri Das, the Learned State Council has submitted that instructions have been received that the concerned portal is not functional.
There is no provision to register a divorce and issue of divorce certificate in the marriage registration section of the NGDOS portal till date. It might be now.
Oh, no. there was no such provision in the existing portal. Full stop. However, noticing that the application under section 12 was filed physically, comma, Sri Das, the learned State Council, is directed to obtain instructions with regard to the procedure to be adopted and the status of such consideration. List on, yes, when?
Next week, develop.
Let him say have some time. Today is 5th, we'll have it on 25th.
Madam.
25, okay?
Madam.
25, 3.
Okay.
Mr. Chaudhary, for which matter? Take some time or what?
It takes some time.
Today we'll have to rise early. There's a meeting and there is something else.
Hello, can I pray for 11?
What is the matter?
Hello, matter is regarding my election as a member of Anchalik Panchayat has been questioned. Lord, there is a recent judgment of this honorable court that they will have to invoke section 129. Election petition.
129 is the bar.
No, but we have said something else.
Lord, today of course there is no time. I can satisfy your lordship's Lord. In one or two.
There's a judgment, my lords, passed by my lord, where my lord has relied on another coordinate-based judgment and has held that an election petition would be maintainable in such cases.
Okay.
But with the deepest respect, my lord, perhaps that judgment was passed by ignoring the binding precedent which was holding the field. My lord. There's a
Also, we'll consider.
Yes.
My lord, according subject
Tuesday.
Next Tuesday, my lord.
Sure, next week, no more.
The only problem is that, my lord, because
there's a stay operating.
Stay operating election is coming, the public are suffering.
My lord, can it be the week next, my lord?
You give us a date of your
No,
consensus.
let it be on 11th.
My lord, next week I have some personal difficulty, my lord. The entire week, my lord, there's some medical emergency, my lord.
Okay, 16th. 16th. Okay. We'll accommodate 16th. But 16th no adjournment. 16th will give, you can mention the matter.
My lord, on 2-3 occasions, my learned friend, sometimes he takes time for affidavit.
Okay, 16th, you make a mention in the morning for upgrading. We'll take it up. If there are many matters, we'll take special
Yes,
at 2 o'clock.
Yes.
At 2 o'clock we'll have. If it doesn't reach us before in the first half, at 2 o'clock we'll have. Okay. Paucity of time will not allow the matter to be taken up today. What's up? Sri Ken Chaudhary, Senior Counsel for the, you're for the petitioner.
No, I'm for the respondent.
Sri Ken Chaudhary, Counsel for the petitioner, for the respondent number 6 has expressed urgency as there is an interim order.
Stay order operating.
As there is an interim order operating. Full stop. Para. Considering the above, list for admission hearing on 16th of March. Full stop. Learned Counsel for the parties would be at liberty to mention for upgrading the matter.
Deeply.
Mr. Roy?
Matter, lordship. Item, it will also take some time. Item number 23. Can it
Your
be
day,
on-
Mr. Day, you're on the other side.
My lord, all matter. Last case was completed.
No, not in this.
No, not your matter.
No.
No, we'll have some date. Is it urgent?
No,
Then he'll give a date.
Lordship, I like that.
Mr. Day, I think your matter we know somebody is, was online, arguing online. We'll have it when? Tomorrow we can have it. Tomorrow? At 2 o'clock tomorrow?
My lord,
Yes, Mr. Counsel, you're online. We'll have it tomorrow online at 2 o'clock.
at 2 o'clock, my lord.
2 o'clock.
Very well.
Have you got the instructions?
Yes, my lord, I've got the
Okay,
instructions.
because today we have to rise slightly early. There's a meeting.
Very well,
Otherwise,
ma'am.
we have heard this matter. We'll just need to some 10 minutes, 15 minutes time to recapitulate. Then we'll have your instructions.
Very well, my
My lord, 26, there's an interim order operating. my lord.
Very well.
In that interim order passed earlier. That was interim order. The application was rejected, so automatically in the interim order passed earlier to extend till the next date. Are we to Kuba? Mr. Day, what is your number? 23. 23.
24, my lord. 24.
Oh, sorry, we forgot your name. What is your name?
Avanish Kumar.
A. Kumar. Heard Sri A. Kumar for the petitioner appearing online, also heard by LCD, learned counsel for the concerned workman. Full stop. Paucity of time will not permit the matter to be taken up today. Full stop para. As the matter was heard substantially, and Sri Kumar, the learned counsel, has informed that instructions have been obtained, comma, list for consideration tomorrow. Full stop. The matter tomorrow. We'll have it at 2 o'clock. We have just
Very well,
informally
madam. Very well,
by slip it will come. Okay.
Okay, madam. I'm obliged, my lords.